1-4. Yesterday we have filed the objection, and the thing is, I have a personal difficulty today. So your lordship may take it up on Wednesday. I have taken consent from the other side, your lordship. PCR has been received, your lordship.
Monday ase niki jaga? Monday ase jaga?
Monday I have a personal difficulty. Monday and Tuesday, your lordship.
Okay, you want it on Wednesday?
Wednesday.
Wednesday Gauhati ke paas jabo. Okay, at the request of the learned counsel for the petition for the respondent, with the consent of the learned counsel for the petitioner, list this matter again on 11th of March.
Highly obliged.
No, please. I like to mention item number 33. This is on the out of station that's on for the petition.
At the request of the learned counsel for the petitioner, list this matter again on
Next week.
13th.
Okay.
13th.
I may be allowed to check the TCR of item 10, my.
CR item 10. Okay.
May
PCR to go to ready no hai day ke mati.
please, lordship, I have to mention item number 15.
15.
15. Due to some personal difficulties of my senior, the matter may be passed over today.
List this matter again on 16th. 16th. Wednesday. Okay, 11th.
May I read, lordship?
11.
Lordship, I beg to mention item number 34, lordship. Lordship, CD not available, lordship.
The CD is awaited.
35.
34.
34.
Yes, there is no December.
CD is awaited. List again on the 20th of March. Are you on interim? No.
No.
Okay.
Wait, please, your lordship. I beg to mention item number 21, prayer for adjournment.
At the request of the learned counsel for the petitioner, list this matter again on
Any date may be given after one week.
16th.
Applies.
May it please, your lordship. Lordship, I beg to mention item number 49, my lord. I'll pass off for a day, my lord. Supplementary days.
At the request of the learned counsel for the petitioner, list this matter again on 18th.
My lord.
18th.
My lord.
Wait, please, your lordship.
Yes.
I beg to mention item number daily list 36 along with supplementary list 51. In this case, CD was called for. It's 36. Daily list 36, supplementary 51. DL 36.
The case diary in the matters are awaited. List this matter again on 16th. 16th.
Supplementary 51. Deeply operational.
You have an interim.
May it please, your lordship. I beg to mention item number 27, lordship. 27, lordship, the informant side have sought adjournment, lordship. Counsel for the informant side.
You are appealing for?
For the petitioner side.
You are for the petitioner.
Informant.
Informant. You want time?
There is a scope of settlement between the parties, so an accommodation is required. Maybe fix after 2 weeks.
At the request of the learned counsel for the parties who submitted, there might be a settlement in the matter. List this matter again on the 20th. Yes.
Lordship, I beg to mention item number 30. Lordship, the CD in this particular case is not arrived. We are on interview.
The case diary is awaited. List the matter again on 23rd of March.
Charge submitted, my
Charge sheet submitted. What do you want to do?
Come up with
Since there is an interim, we'll close it. Making the absolute, and you go and appear as and when you receive the summons. 30 to 9, mentioned 32 order pass episode. 30,
Yes. Lordship, I also beg to mention item number 39. The engaged counsel has some difficulty today. It may be listed after.
At the request of the learned counsel for the appellant, list this matter again on 23rd.
18th or 19th is possible.
18th.
Lordship, item 27, there is an interim.
The interim order continues 27,
Obliged.
Your Lordship, another
Yes.
item number 17, Your Lordship.
17.
Your Lordship. Can it be taken up on Monday or Tuesday, Your Lordship?
Tuesday.
Deeply obliged.
17, my lord, 4 days.
You were mentioning item number 17.
Yes, sir.
17
Yes, Your Lordship.
We have received information that charge sheet has been submitted, madam.
in item 17.
Item 17, madam.
But
Tuesday or
let the charge sheet be called therefore, because we are not a mentor.
let the matter reach.
You can.
Let the matter reach. We'll see what to do.
2022.
We have allowed the writ petition requiring the respondent number 3 to make the payment of the contracted award. And they may avail such remedies regarding the equipment supplied as is allowed under the contract. Yes.
Motion clear, item 2.
The second bill application
Okay.
filed by the petitioner.
Huh.
The petitioner is a teacher and he is accused of abetment of suicide. And
Huh.
the main case on Bhikkhu Setri, he was in jail.
Huh.
Here, Lordship, see page 42.
42.
42. There is no any allegations against the present petitioner. Page 42, I have bolded it is a part of the charge sheet. Very unfortunately, on 6/7/2025, the victim of this case committed suicide at home by hanging. In a 4-page suicide note left behind, the victim stated that due to the misconduct, one Sri Bhikkhu Setri, this is another accused person, she felt too ashamed to go to school. That the headmaster prevented her from attending the school, and that being unable to sit for her exams drove her to take her own life. There is no any allegations against the petitioner.
You were not the headmaster.
We don't know, we are the other teachers, because there was a meeting. Your Miss C. Page
Tree.
75. Page
Ah.
75.
Page 75.
Yes, yes.
What does it say?
This is the because this Bhikkhu Setri has done this has physically exploited the victim.
Huh.
So the headmaster and the managing committee has written a letter to the guardian of the victim girl. May I read? With due respect, we would like to humbly inform you that in connection with a complaint made by your daughter, it has been decided to convene a meeting at a school. The meeting will be held with the school penance committee, the teaching staff, and the guardian to discuss the matter. Therefore, you have requested to kindly attend the said meeting at the school at 2 p.m. along with your family and your daughter. This is a signature by the Kulandu Upadhyay, the president of the managing committee, and the member secretary. We are
No, why has your client been taken into
because we are
custody?
present. We are present in the meeting.
Okay.
We are present in the meeting, and in the meeting, and 40 persons have gathered. So on that on 9/6, the FIR was lost. I given this list of dates on 26 on this on the front person. On 26/5, the victim was raped by Bhikkhu Setri. On 3/6, the victim consumed phenol in a school premises. On 6/6, victim informed the mother. On 9/6, meeting was held in the school. On 9/6 in the evening, the mother lost the affair on 9/6. On 6/7/25, the victim committed suicide. After losing the affair, there is after 1 month. So there is no any proximity link with the suicide of the because any allegation is there with the headmaster and this main person is Bhikkhu Setri. For an offense of suicide, there should be instigation. The instigation should be in possibly linked with the commitment of suicide. And there's only 111 days behind the bar.
On the last occasion, we had taken both the bail petitions of Dipu Chetri and
So there's just
This person,
4 teachers. Viku Sethi is the main accused. Other 3 teachers, Nikhil Devnath, Dipu Sethi is the headmaster, and one another person is there. They are the other teachers who were present in the meeting.
any statement against Nikhil Devnath that he had
In
tried to dissuade the
the
person?
police investigation, there's that we have for our actions the victim has committed suicide, but there is no any suicide note. Only as per the search sheet given by the police, only that person. Page 42. This is written in the vernacular. So the logic of the affair after and the commitment of suicide by the girl, this there is a time of around 1 month. So for a offense to be not suicide, there should be some instigation and a proximity of link. In this regard,
No, the suicide note says that because she was not allowed to attend the classes and she was put to shame, she committed suicide.
yes, because
Now, what on the last occasion we had gone through the records just and we found that all the persons were involved. We did not take it up on a person-wise basis.
in the page 42, in the vernacular it is there. In the page 45.
What does it say?
অতি দুৰ্ভাগ্যৰ বিষয় এইটো যে ইংৰাজী 6/7/2025 তাৰিখে এই মোৰ ভুক্তভোগীয়ে নিজৰ ঘৰতে চিপ জৰি লৈ আত্মহত্যা কৰে। আত্মহত্যা কৰাৰ আগতে ভুক্তভোগী এখন বহীত লিখি থৈ যোৱা 4 পৃষ্ঠা ছুইচাইড নোটত পদকীয়া শ্ৰী বিকু সেঠী the main accused ভুক্তভোগীয়ে সৈতে কৰা
Which part are you reading?
page 45 bottom part last paragraph. বিদ্যালয় যাবলৈ নিষেধ কৰা আৰু বিদ্যালয় যাবলৈ সংকোচ কৰি আৰু বিদ্যালয়ৰ প্ৰধান শিক্ষক there is an allegation against the headmaster তাইক বিদ্যালয়লৈ যাবলৈ নিষেধ কৰা আৰু পৰকীয়া পৰীক্ষা দিবলৈ নাপায় আত্মহত্যা কৰাৰ কথা উল্লেখ কৰি গৈছে whether there is instigation on the part of the direct instigation, whether there is a proximate link in the suicide of the victim, that the Supreme Court in a latest judgment in Mohit Singhal versus State of Uttarakhand has gone through. Only 111 days have passed.
The allegation against you is at page 46 that you were one of the persons who had asked him not to approach the police.
That section is around 239. Intention to omission to give information. This is available section. Bound to inform of the
39, 107, and 61.
yes. 61 is not 61 is not applicable. 239 and one is there. This is available. In that meeting, as per this Kulandu Upadhyay was made a witness. He was not made an accused. He was the person.
Who?
This the person who has arranged the meeting. Kulandu Upadhyay was not made an accused in this case. He was the main person who has organized the meeting. It is page 75. And headmaster was there, but as he's the president of directed all the staff, all the staff of the school were present, and the guardians, other councils were present, and the local people were also present. Page 75. And the vernacular is at page 76. The main country is Bhikkhu Sethi. He has done everything. Whether not going to admitting not for arguments I am saying, whether the teacher has said, don't come to school, whether this instigation.
We will have to issue notice to the respondent number 2 as of today. But okay. But Mr. S.R. Gogoi, Learned Counsel, paying for the petitioner. This is the second bail application. The earlier BA number 3993 of 2025 was rejected by this court. By the order dated 12/12/2025, the Learned Counsel for the petitioner has submitted that the investigation must have substantially progressed. Therefore, made a prayer for a reconsideration of the prayer for bail to the petitioner. Full stop. Call for the case diary. Issue notice to the respondent number 2. Petitioner to take steps. List again on, where is it? In Sukia. We'll have it on 25th of March. On the 25th of March. Mr. Bonik, you were here on the last occasion in this matter, that school matter, where a child had committed
Yes,
suicide.
and they tried to rope in the persons and grease palm the way out.
There were
yes, yes.
three or four
Three
teachers who
were
were
there.
trying to
Yes, of course.
convince the lady, and she
Some-
committed suicide. You were there in the matter last time. Today the matter has come up again. We are issuing notice. He'll take steps. Meanwhile, because you appeared in the last time, we thought we can bring it to your notice.
No, I have to obtain the.
You have to. He has to take his instructions. He was there on the last occasion, but since he was present in the court, we thought we should bring
My
it to
father
his
expired because of this. My father expired, my mother was hospitalized.
of the
Because-
petitioner.
Yes, because of false implications.
No, the allegation against you is not that
There-
you had participated in the crime itself. The allegation is that you had tried to dissuade the
Yes.
persons from disclosing.
I'm saying that in the meeting, except me, there are many persons who are present. The main person who organized it is Pulandu Fighter. It's annexed this.
Yes.
I'm as a teacher, as directed by the headmaster and the president.
On the last occasion, this court was swayed by the thought that a girl had been stopped from asking for justice, and that led to the death.
Yeah.
So anyway,
After one,
let us.
she has committed suicide. There's a proximity of link between suicide. There is pure instigation. Let us report judgment is Mohit Singhal. Mohit Singhal case.
We'll have it on the 20th. We said 23rd, huh?
25th.
25th.
Mass applies.
This is Harshit matter, my lord. So in spite of CD, my lord.
Oh,
ECR may
the Mr. Gogoi, charge sheeted.
Yes.
It is a charge sheeted case. We call for the CD. We'll call for the TCR.
Yes,
instead. Call for the TCR. Call for the scan copy of the TCR.
Applies.
Yes, you want to withdraw it? The Learned Counsel for the petitioner has submitted that she is under instructions not to press the matter in its present form. Accordingly, the prayer for withdrawal is allowed.
May I please tell you? In this case, my lord, I have been grabbed in this case. Although, my lord, I'm not connected to that case, my lord. I'm, my lord, discussed, I have elaborately mentioned in my petition. And also the procedural irregularity, I have filed an additional affidavit. For a moment, kindly see my additional affidavit.
Yes.
My lord, kindly see page 27, para 4. May I read now? That the deponent begs to state that the offended vehicle was intercepted during conducting narco checking duty at around 10:20 AM on 22/9/2025, and completion of seizure was done at 12:25 PM on 22/9/2025, and the departed the PO at about 2:20 PM. The time of seizure is duly reflected in the seizure list. That the deponent begs to state that the petitioner, along with the main accused, forwarded to the Honorable Court of Judicial Magistrate on the next day, that is on 23/9/2025, where the date, time, and place of arrest is mentioned as on 22/9.
Just a minute, you were in the vehicle.
Police saying that I am in the vehicle, but
Ah.
in fact, this is not my.
Just a minute, you are saying you were not in the vehicle?
I'm not in the vehicle.
The vehicle was intercepted on 22/9.
22/9/2025 in the morning,
Ah,
10:20.
okay.
And
Then,
my lord, they were forwarded along with the main accused on the next day at night, 8 PM, my lord, at night, my lord.
where do we find it?
Yes, my lord. That, my lord, kindly see page 28,
No,
para
just a
6.
minute. Then the petitioner along with the main accused forwarded on 23/9.
On 23/9/20, where the date, time, and place of arrest is mentioned as on 22/9/2025 at 11 PM. At Pazarisara PS. However, the notice under section 47/48, the date of arrest was shown as 22/9/2025.
23/9.
Both are different, my lord. In the arrest memo under section 36 BNSS, the date and time of arrest is shown as on 23/9/2025 at 11 AM.
Hmm.
In the charge sheet, the date of arrest is shown as 23/9/2025. That the deponent begs to state that the person to the GD number 4 dated 23/9/2025 at 1 PM, the seized contraband was got out from Malkhana and handed over the SIL Crow. The petitioner was forwarded to the magistrate at 8:28 night on 23/9/2025, which is duly reflected in the GD number 15. On perusal of the records, it clearly reflected the petitioner was detained in between 10:20 AM to 12:25 PM on 22/9/2025, and he was forwarded to the magistrate after 8 at night and 23/9/2025. As such, the petitioner was under police custody for about 32 hours. Now, my lord, kindly see page 29, para 8.
Pera?
Para 8, my lord. That the deponent begs to state that on that day, on 22/9/2025 in the morning, one phone call from main accused Rajibuddin was received by the petitioner that he had to come there for some help as the vehicle was got sold, because I am a mechanic by profession, bike mechanic. He had to come there for some help as the vehicle was got sold to with the help of the petitioner. That I have discussed now, how I have connected with that vehicle in my petition. Sold with the help of the petitioner. Being innocent, the petitioner
We're
went
not
there
going to all that. We'll just go for the 32 hours. 32 hours without production.
without production. And fact is that, my lord, I have elaborated discussed in my petition how I have been mingled with that case.
Have you got the additional affidavit?
No, my lord, that I have.
You have not given him a copy?
Yes, I have already given, my lord. That was served.
We have not received, my lord. Let us survey copy, my lord, we'll go through, my lord.
My lord, I'm serving now.
Matter may come up on Monday, my lord.
My lord, kindly at 2, my lord. There is nothing.
How many respondents are here?
Only PP, my lord.
And who is Sultana Pradhani? Arita
He is my
Sultana.
junior, my lord.
She says, I was unable to complete service upon the respondent number so and so. You cannot serve the PP.
I have served.
Huh?
My lord, I am serving.
There is only one office of the PP.
It is
Someone other else is always present there. But this is misuse of our order. When we say that without serving copy, you cannot have it listed.
Generally, I serve, my lord. I know that I am serving now, my lord.
No.
At present, I am serving.
Just a minute. 26/2. Again, there is a notice which says that you received it.
Yes, my lord.
I do not know, my lord. We have
When? Monday?
Monday, my lord.
Monday?
Today, there is no.
No, I am only praying for Monday, my lord. Today we have got similar matters, several matters, my lord. We do
Matter
not
is
think
very.
Once you give him the copy, he will have to ask his office that these are the timings given. Give me the papers. Is it not? Monday. The learned counsel for the petitioner undertakes to serve a copy of the additional affidavit on Mr. So-and-so, learned counsel, learned APP, appearing in the matter. Accordingly, list this matter again on Monday. Monday is what? 9th.
One copy to serve, my lord.
Yes, one copy.
May I please, Lord, sir? For a retrieval application, regarding respondent number 2 is a POCSO Act. Respondent number 2.
Yes, has the respondent been served?
My lord, that is awaited, my lord. Allow us some more time, my lord.
See, on the 6th of February, someone takes steps.
My lord, we take some instruction tomorrow, my lord.
Huh?
By tomorrow, my lord.
Tomorrow is Saturday. Tomorrow we are not here.
Um,
And you are there, that would mean 2 more extra days for him to rot in the. Huh?
Apology, my lord.
Where is the FIR?
My lord.
Okay, by Monday, have your
Monday.
list again on the 9th of March, by which time the Learned EPP shall have instructions on the service of notice on the
Right.
respondent number 2.
Deeply obliged. My lord, this matter also, my lord, this service is awaited, my lord. That is, we need some time, my lord.
My lord, the petitioner is in custody since almost 6 months, my lord. And we allow a short date, my lord.
My lord, Monday itself, my lord. Allows.
Huh?
Monday. Both the-
We are not happy with the
My lord, my lord. I beg
service
apology,
report,
my
but
lord.
we are not
I
at
beg
all happy.
Apology, my lord.
It's my lord, it's second time, my lord.
Huh? P22026.
My lord, my lord. I have
Matter
done
is
the-
fixed for?
I have gone through, my lord.
Huh?
My lord, by Monday.
Not happy. List again on the 9th of March, by which time the Learned APP shall have instructions on the
My,
service of notice on the respondent number 2.
my,
That's my lord.
Beg your lordship, my lord. On the last occasion, my lord,
Yes, Diary?
Your lordship, asked about the main accused, my lord. My instruction is this. My instruction is that, my lord, I advised the absconding accused to surrender before the court, my lord. Accordingly, he has surrendered before the special judge, Dalbury, my lord. Now he is in jail, my lord, main accused. For my lord, for me, my lord, I am the wife of Matissa Demari, who is the main accused, my lord, and I have gotten a 7-year-old child who has been missing his school days, my lord. I could not go to his school because I have been in jail with my mother. I have already completed 3 months, my lord. Only 2 days left. 3 months, almost completed 3 months, my lord. And
Yes.
relating to the, my lord,
The main accused has surrendered.
Surrendered, my lord.
She's the wife.
Is the wife, mother, but
They have a son.
contraband is recovered from the, my lord, wife of the petitioner.
No, because the other fellow had run away and the wife cannot run out of the house.
No, that is not the
She
case.
should have run away together with the husband, no?
Now we have to go by the Caesar list, my lord. Now it's a 76 kilo ganja was recovered, my lord. And the matter is pending, my lord, to collect the, my lord, FSL report, as well as the, my lord.
We assume it is ganja. We presume it is ganja. Then?
My lord, then, my lord, the commercial for the records of 37 will come, my lord. That satisfaction lordship will have to draw, my lord.
Your lordship may impose any condition, my lord, any restrictions. Your lordship may impose any conditions, any restrictions. If any of the conditions or restrictions is violated by me, my lord, my bail should be straightforward, be cancelled, my lord. I shall be put again to in jail, my lord.
What is this statutory period?
180 days, my lord.
180 days, my lord.
And in fact, my lord, the FSA report also received, my lord. I'm sorry, my lord.
Hmm?
I could not point out, my lord. FSA report also received, my lord.
Received.
Received, my lord.
We presumed it is ganja.
Yes, yes.
We presume it is ganja. That is why we started with presume it.
My lord.
Factors are that both the parents now behind bars with their 3-year-old or 7 years old child.
7 years old one.
Hmm?
7 years old.
Do you have the child?
The side aspect is different, my lord. Lordship may kindly go through, my lord, these two statement of these two witnesses, my lord. One is Caesar, my lord. How the contraband was recovered and what manner, my lord.
Some was under the bed and one was in a this thing.
The wife has a knowledge, my lord. That is why. It is not that my lord, wife does not have any knowledge, my lord. And it is recovered, my lord, from them an abandoned house or my lord, abandoned house of the accused person.
Abandoned house of the accused person.
But maybe my accused number 2, 1. My lord,
Abandoned house.
It is not that like that, my lord. She has way, my lord, knowledge, my lord. This is the witness statement of the Caesar witness, my lord. And next statement is the accused person, my lord.
Okay, we'll pass our orders. We are retaining the CD for some time.
My lord.
We'll pass our orders.
Highly obliged, man. Highly obliged. My lord,
Good,
my
good,
name should
good,
be, my lord, we are twins, my lord. My brother, we are twins. My name should be written as S.S.A. Rahman, my lord.
S.S.A. Rahman.
Rahman, my
Huh? Heard Mr. S.S.A. Rahman. Okay.
Highly obliged, man.
CD received. 16.
Case diary, my lord.
Huh?
16 is adjourned, my lord.
16 no, 17 actually.
17 is search set, my lord.
This is 16.
16, my lord, CD not received, my lord.
CD not received. Wait, the CD list again on.
Sorry. Yes.
They say the CD is not received.
3 months already there, Lordship.
Huh?
30 days are already completed here, and the vehicle which are mentioned in the FIR at page 15 in my application, Lordship, are already being recovered, but I have availed the certified copy of the Caesar list, Lordship. May I place it, Lordship, the Caesar list? It's already been recovered, Lordship. Page 15, informant says that his vehicle being taken by executing an agreement with a promise to pay 35,000 monthly rent, and followed by that agreement, he did not pay and could not trace out. So this affair has been lost. Now, Lordship, It's been traced and recovered, Lordship.
This one, Nunmati PS, my lord. You can fix it on the next week.
Hmm?
Very much.
The two vehicles involved have been,
Vehicle, my lord. It was.
but there is an allegation that there are other vehicles involved. Is it not?
In fact, gradually seems not to be the owner.
Hmm?
The Caesar list will reveal.
Which one? Gradually. It's the Hyundai Creta.
That was the
Oh, it reached Naharlagun. The vehicle is recovered from Naharlagun.
It was in rent. It was placed under higher lordship on monthly rent basis. By executing, that is there in the FR lordship, by executing an agreement,
Hmm.
he himself, with the consent of the owner, it's been placed lordship on higher lordship. He was receiving rent for about 1 year,
Yes.
1 year or 6 months.
Since the CD is awaited, we'll have it on when Tuesday or Monday.
My lord, we'll have it
Huh?
on the 10th, my lord.
Vehicles are recovered. They were under an agreement. There is nothing here to show that there was any sale of the vehicle itself.
My lord.
Is it not? Because one person from Arunachal has produced the Vitara. So whether that was sold or not is only what is stopping us. Otherwise, the vehicles are recovered. They are under agreement.
That will verify, my lord.
There must be some
Because in the
misdoing.
forwarding
They did
report,
not
my
pay
lord,
the
there-
rent, so he lost an FIR key. He's trying to sell it off. Could be, we do not know.
In the forwarding report, my lord, there are some
And the
elements.
FR lordship cannot improve their version more than the FR.
In the charge sheet itself, in the forwarding, there is one reference to another vehicle, which has also been recovered from some Arunachal Pasigat.
Yes.
We'll have it on Tuesday. We'll have it on Tuesday. Let him have an attempt at the CD. We are keeping the certified copies with us. See, Tuesday, whether or not the CD will take a call.
My lord, my lord.
Huh?
The
The
10th,
learned,
my lord.
Miss Som, learned counsel appearing for the petitioner, has submitted that the alleged vehicle, that the vehicles which were allegedly sold off had been recovered, and there is no proof of sale. Full stop. The learned APP has sought for some time to have the updated CD.
My lord.
List the matter again on 10th of March.
My lord.
Yes.
I'm obliged, Lordship.
Lordship, here, as per learned counsel, the charge sheet was submitted.
Charge sheet submitted on, my lord, 27 to 2026, my lord.
Hmm.
By charge sheet number 20/2026.
Hmm.
Charge sheet number dated 27 to 2026.
Actually, accordingly, the huh?
Records 24.
Call for the scan copy of the PCR. What about the steps?
No, might just be required, your lordship.
Huh? 24/2. Today is the 6th.
Amendment may be appointed, my lord.
Why?
Sir, because charge sheet has been already been submitted, my lord.
Hmm.
And we have also not received the, my lord, information, my lord.
The service report on the respondent number 2 is yet awaited. since the matter is charge sheeted, at the suggestion of the learned EPP. This court appoints Srimati P. Das as the amicus curiae to assist the court in the matter. List again on
Any day, my lord, TCR has to be called for.
23rd,
My lord.
23rd of March. The counsel for the petitioner shall serve copies of the bill petition on the learned amicus.
Deeply obliged.
In my lord, forest matter, my lord. This is my lord, succeeded matter. So kindly have my lord, offense report, my lord. It is already fixed on my lord, evidence days, my lord. Kindly have a look at my lord, page 17.
Page
17, my lord.
17.
My lord.
What is that?
Last para, my lord, 12. Charges has already been framed and case is fixed for evidence.
Lordship, in this case, TCR needs to call for.
This year.
Hmm?
This year, my lord.
When were you arrested? 23/12.
10 August 2025.
10th of August.
My lord.
Till date 207 days already complete.
Short.
Hmm?
It is from Karbi Anglong.
Hmm.
Can. Posting on my lord barking deer.
Huh?
Posting on my lord barking deer. Caracas of barking deer.
Call for the scan copy of the trial court records. List again on the 23rd.
My lord. Well,
23rd March.
Lordship, kindly fix a short date.
18th. 18th of March.
Well. 19.
Yes, Lordship. My lord, regular bail application.
Huh?
Lordship, 23 days behind the bar, my lord. FIR may be seen at least 7, my lord.
CD received? No.
Yes, that is received, my lord.
Received?
Received.
My lord, FIR page 7.
Scooter is missing.
My
Yes.
lord.
Scooter is not recovered, my lord. Otherwise I would have not objected, my lord.
My lord,
They have sold to somebody else, my lord, and they do not know who is the person, my lord.
You don't even know whom you sold it to.
On suspicion, my lord, he was arrested.
Huh?
Suspicion, my lord, on the basis of secret information, my lord. Both the accused persons were arrested, my lord. And he is one of the accused
My
persons.
lord, page 14 is the forwarding report, my lord.
Hmm.
My lord, 23 days, my lord, he is behind the bar.
So we are taking away scooters when people are going to shopping. They
This
come
is
back with a
happening-
handful of grocery and they find nothing.
This is happening, my lord, in entire Gauhati city.
The forwarding report says, my lord, they were loitering around the place of occurrence on 10 to 2026. And this incident happened
my lord, in the month of December, 8th
Hmm.
December 2025.
Forwarding says they were seen loitering in another area on 10/2/2026. Is it not?
No, my lord.
Are we reading it wrong?
Page 14, my lord, ground of arrest. During the investigation of the case, information was received from the reliable sources that two suspected persons were seen loitering around the place of occurrence on the date of commission.
On the date of commission of the crime. Full stop. On dated 10 again.
Again, information received some sources that the similar persons were loitering around Sundarpar area. An incident was also, my lord, Baghorbori, that is Baghorbori area.
Baghorbori when you enter through the other side. Sundarpur when you enter through this side. And sold at Panjabari, common point.
Lordship. But considering the length of
No,
detention,
23
nothing
days
recovered.
when you're stealing scooters, 23 days is nothing. At this stage, no. If it had been recovered, it was another issue.
Yes, my lord.
Had Mr. Swain and counsel paying for the petitioner, huh?
At this stage, my lord.
At this stage, at this stage. Also had Mr. Swain and APP appearing for the state. The case diary has been received and perused. The stolen scooter is yet to be recovered. Investigation is at a nascent stage. In view of the circumstances, this court is not inclined to grant the privilege of bail to the petitioner at this stage. Accordingly, this bail petition is rejected at this stage.
All right.
Wait, it's a lordship.
Case that is not received, my lord.
Well, it's a charge sheeted case and we prayed for calling for the TCR, but CD was reflected.
The learned APP has submitted that the case is charge sheeted, but the order dated 22/2026 reflects that the CD had been called for inadvertently. Accordingly, call for the scan copy of the TCR
Yes,
in the connected matter. List again on 20 March.
My lord.
Let it be on 26th.
26th.
Yes, ma'am.
26th of March.
But from the court of learned special judge Shibumi.
এটা আগৰ অৰ্ডাৰটো পৰা চাই দিব কাপৰা আনিব লাগে TCR of so and so from the London court of so and so.
21 to adjournation.
21 to
22 searches submitted, my lord.
Today is the 60 day lordship. This is 60 day lordship.
Huh?
Today is the 60 day lordship.
Searches submitted on 28.
Charge sheets submitted earlier. You'd like to try there or should we call for the records?
Proceed. I've tried there.
The learned APP has submitted that the charge sheet by CS number
19/2026, dated 28/2/2026.
has been submitted. Learned counsel for the petitioner prays for the liberty to approach the learned trial court. Stop. Accordingly, this bill petition is disposed of, allowing the liberty as prayed for.
Wait, is your lordship.
Hmm.
Lordship, this is a regular bail, 64 days. Today, lordship, last day, lordship, I pointed out regarding 193 of BNS, lordship. 63 days is the statutory period, lordship, he had 64 days.
Let us verify, madam, whether search is submitted or not. After some time, madam.
After some time. That we can allow.
I leave.
24.
May I please double check?
Hmm.
Regular bail application lordship. FIR lordship, fine at page 12 lordship.
Huh?
Page 12 with the FIR lordship.
12.
May I read the FIR lordship?
Huh?
Page 12 lordship.
My lord, before my learned friend starts, my lord.
Huh?
In this case, my lord, the 183 statement of the victim is not available, my lord. So
But we had given a separate, we had given a different indication in our last order.
regarding the age, my lord.
Ah.
Yes, my lord. Now, my lord, we have verified from the investigating officer, my lord. My lord, he said, my lord, maybe it is misplaced, my lord. So he has paid for
What is
maybe
this?
183 statement of the victim is not available in the case diary, my lord.
Was it recorded?
Yes, my lord. So we have inquired from the police station, my lord, from the IO, my lord. He said, my lord, it may be misplaced, my lord. So he has paid for 2-3 days time, my lord.
Yes.
He will verify, my lord, and he will read it.
What is the age you said?
The petitioner age is 20 years, Lordship, and victim age is 19 years, Lordship. And the incident occurred in 2022-23, Lordship. That was the petitioner's age was at that point of time 17 years, Lordship. 40 days in custody, Lordship. Second semester student, Lordship. I have annexed also identity card, Lordship, page number. Lordship, can you see page number 15, Lordship. The forwarding report also mentioned that his age is 20, Lordship. I have also annexed the
Why are you not giving the school certificate?
Lordship, I have annexed the identity card, Lordship, of the school, Lordship. Page
This
number
is school.
Yes, Lordship. Page
No.
number 15. The
This is college.
College, Lordship. Demo College, Lordship.
He
Identity
must
card.
have his parents must have his school leaving certificate, matriculation certificate.
Lordship,
That is the proof
that is the
for both the victim and the accused.
But the forwarding report, Lordship, clearly mentioned that his age is 20, Lordship. Lordship, may kindly see page number 13. I have annexed the forwarding report, Lordship, is a official record, Lordship. Lordship, may kindly see page number 14. On 20 years plus paragraph, Lordship. Page number 14, Lordship. It's clearly mentioned his age is 20 years, Lordship. Is recorded by the police, Lordship.
But you are using those photographs now.
No, Lordship, considering the length of detention as well as Lordship.
You are using those photographs now from a WhatsApp number. That number is yours.
Mobile has been seized.
Huh?
Mobile has been seized, my lord.
The same number.
Yes, my lord.
Where do we find it?
From the seizure list.
It is there with you. What is the phone number in the seizure list?
My lord, the phone number is not given, my lord, but IMEI number is given, my lord.
That doesn't matter. We'll have to have the.
Yes, my lord. Phone number is there, my lord. 60019 60078, my lord.
Oh. Oh. He might have been a minor then when he took the photos. But viraling it now is.
Yeah, okay, Lordship. But POCSO Act will not apply, Lordship. The POCSO section 14 and 15 is added, Lordship.
Huh?
Section 14 and 15 added, Lordship. That section may not be applied in this case, Lordship.
Why not? Why 14 is not? Why not 14 and 15? He stored it.
When it is used for the purpose of pornography purpose, Lordship. When the photography is used for the pornography
Was it being used for some medical purpose?
No. Especially mentioned that when that photograph is used for the pornography purpose, Lordship, then section 14 and 15 will
That is what we are asking. When he viral the photos of the girl, did he do it for medical science purpose?
No, Lordship.
Obviously not. He did it for purposes which are not permitted in law. Is it not?
Considering the length of detention, Lordship, 60 days is a mandatory period, Lordship, and it is a second semester student, Lordship.
At best we can wait for that 183 statement. Otherwise, we are not inclined as of now.
The shorter may be given then, Lordship. 40 days as of
When can you have it?
My lord, on 16th, my lord.
16th?
Can it be shorter date, Lordship?
13th?
16th.
Huh?
But we have to, my lord, get the 183 statement. My lord. I will have to, my lord, take back the CD and have to enclose the 183 statement, my lord. So I'm just praying for, my lord, short date only, my lord, 16th.
16th? The request of the learned APP who submits that the 183 statement of the victim girl is not available in the CD and he will have the same brought in, release this matter again on the 16th of March.
47.
We are not happy in roping you in, but
That's fine.
otherwise, if the 47, 48 notices are not there and the DRI is not appearing before us.
In fact, last evening I called up Mr. Kyal. He happens to be the standing counsel. He should have been here. I don't know why he's not here. It's an abundant caution. I am here, Lordship.
We have seen that record. It was gone through by the APP. 47, 48, we have not been able to trace up. Perhaps your assistants can help you to have a relook.
If I can.
Yes, please, please. We'll take it up after some time at your convenience.
Lordship can take it up after 5 minutes.
Just indicate it to the courtmaster. Yes. Tell us.
Lordship, we have not received the copy in this matter. And
What?
Lordship, we have not received.
You do not have the cause list also.
In this case, my lord, just I have checked today morning, my lord, though I am APP, here Minal Boro was there. Now, my lord, he perhaps joining as a APP. Newly. He should have informed, my lord, otherwise you check.
We were not aware, Lordship.
Huh?
We were not
You did
aware.
not see the cause list for the last 2-3 occasions.
Lordship, there are other councils as well.
Huh?
Lordship. In DRI, there are other councils as well.
Now we have sought the help of Mr.
To serve us a copy.
We have requested, the only issue is the 47 and 48 notice. Nothing else. Mr. Chaudhary is here. Assist him. We'll try to find out if there is a 47, 48 notices there or not. If the 47, 48 notice is not there, even your appearance is not going to cause any sudden magic to it. If the notices are there, whether they are sufficient or not, we will await Mr. KL perhaps. But if it is not there at all, done.
Okay.
Yes.
60 days, Lordship.
Yes.
60 days, my lord.
Not submitted.
I said no service.
Yes, not submitted. Ms. T. Somnora counsel for the petition has submitted that today is the 60th day. And yet the charge sheet has not been submitted till now. Learned APP on his has
Not on default bail, my lord, but not on default bail, my lord.
the period of
Because default bail will come tomorrow, my lord.
on the period of detention.
Then.
This is a application under section 483 of the BNSS seeking regular bail in connection with Haju PS case number 442 of 2025 under section 21B/29 of the NDPS Act. The recovery alleged from the petitioner is
37 gram heroin, my lord.
Not for petitioner, Lordship.
But the recovery alleged alleged recovery in the matter is 37 grams of
Heroin, my lord.
heroin. Where were you at the point of time?
Page. I was not there, Lordship. I was subsequently arrested. 18
The petitioner had been arrested subsequent to the recovery. Full stop. Considering the length of detention and the quantity allegedly recovered, which was also not from the petitioner, this court is inclined to grant bail to the petitioner on the on his full stop. Accordingly, it is directed that the petitioner shall be released on bail on furnishing a bond of ₹30,000 with 2 sureties of the like amount, subject to the satisfaction of the learned trial court. Full stop.
As this name Hazu.
No.
Of the jurisdictional court, of the jurisdictional court, full stop. The bail shall be further subject to the following conditions. Not to leave the regular NDPS and one of the the learned jurisdictional court shall have the liberty to impose such other conditions as will be required to ascertain the presence of the petitioner as and when required.
My lord, only one line may be added, my lord. Charge sheet could not be submitted due to non-receipt of the FSL report.
The learned learned APP has submitted that the charge sheet could not be submitted because of the non-receipt of the FSL report.
I'm obliged.
What is the amount of surety?
30,000, 2 sureties like amount.
And the blood.
25. Hearing. Hearing 25.
Please, your lordship.
Huh?
Lordship, CD was called for.
CD, is it received? Received?
Case diary received, my lord.
Ah.
Lordship, interim was there.
Hmm.
And Lordship, accused person was appear before the IO. And IO already recorded his statement. Lordship, fully cooperate with the investigation officer.
Hmm?
Then Lordship, accused person appear before the IO and IO was recorded his statement. Then Lordship, accused person fully cooperate with the investigation officer. Then Lordship, absolute maybe continue. Interim may continue.
We require the up-to-date case diary, my lord. His statement is not available in the case diary.
The learned APP has submitted that the up-to-date case diary would be required since the statement of the
Accused person is not available.
petitioner, who has appeared before the IO is not found on record. List the matter again on the 20th. 20?
My lord, no, that will be on 26/3.
26/3. Interim protection granted earlier continues.
Published.
28.
Yes, sir.
My lord, CD was called for.
Ah.
28, my lord, case diary not received, my lord.
So, my lord,
The CD is awaited.
and, your
The
lordship,
CD is awaited. List again on 26/3. Interim order continues.
my lord, it is from 5/1/2026. CD is not received.
You are under protection.
Yes, my lord.
Even if we dispose of the matter, you will still be under protection.
My lord, my lord.
Let us have a look at
Order
the
maybe
CD.
until further order.
Huh?
Interim order will continue until further.
My lord, I am sorry, my lord. In this case, search is submitted, my lord.
Charge sheet submitted. You can close the matter. The learned APP has submitted that the matter has culminated in a charge sheet being CS number.
CS number, my lord, 34/2025,
Huh?
dated 23/2025.
In view of the above, the interim protection granted to the petitioner is made absolute. Petitioner shall approach the learned trial court on receipt of summons.
Much obligation.
29.
29 also, my lord, search is submitted, my lord.
I am in interim.
CS number to লৈ লওক, বাকি order to একে থাকিব।
CS number 32/2026, dated 4/3/2026.
Approach the learned trial court as and when summons are received.
30 also search is submitted, my lord.
Same order. Provide search sheet number.
Search number 25/2026, dated 27/2/2026.
Interim order is made, interim bill is made absolute. Petitioner to approach the learned trial court as and when summons are received.
Or the committal court, your lordship, because one of the cases, one of the.
Committal court. The trial or the committal court.
Deeply obliged, Your Lord.
31 to CD2.
41, lordship, earlier FSL report was called. It's regarding that seizure of meat, lordship.
And after some time, my colleague has gone through the case diary.
We'll make it absolute. He was carrying some meat. Huh? He was carrying some meat. Is it not?
32.
Yes.
For the order of this honorable court, the additional affidavit was filed. Only summons and order passed by the trial court. I'm ready to appear before the.
Case diary not received, my lord.
Is the case diary? No. Case diary received. Last order says.
No, my lord, he was shown absconder in the search sheet, my lord. So, my lord, TCR, my lord. TCR.
Why do we need the TCR? The additional affidavit is not on record.
Affidavit filed, Your Honor. Affidavit filed, Your Honor.
It is filed, but it is not on record, sir.
It has to be on record, Your Honor. Copy of the.
What had happened? What had happened?
What has happened? For livelihood, driver, Your Lordship. For livelihood, I am walking in Arunachal Pradesh, and the summons was issued to a place in which I was earlier a resident,
Just a minute.
then presently I'm residing
জয়মান
somewhere.
তারিখে আবেলি প্রায় 2 বজাত মোৰ ছোৱালী শ্ৰীমতী কুমকুম দলে
থাকে present চলাই লোৱা। সেইটো পটককে বিলো দিব নিলে নাই।
Then you remained an absconder.
Yes, because the summons are not being received by the person concerned.
Huh?
Person concerned is living for his livelihood at Onitsal Police. He's a humble driver, Your Honor.
But this is a case of POCSO, my lord. So notice will also.
Yeah, I'm ready to face the trial, Your Honor.
Not without your additional affidavit and also the
Hearing the informant, my lord.
informant. You have not made the informant a party. Huh? Oh, you have. The learned counsel for the petitioner has submitted that the required the additional affidavit has been filed, but the same is not found on record. List again on. We'll have it on the 10th with your additional affidavit.
Can
TCR may be called for, but scan go.
Okay. Then we'll not have it on the 10th. Issue notice to the respondent number 2. Under the prevalent notification, petitioner to take steps within 3 days, 3 working days. Call for the scan copy of the TCR. List again on, we'll have it on 24th, 23rd of March. Huh? 24th of March.
May I please, Your Lordship, well, CD was not provided, the CD received my
Received? Yes, what do you say?
FIR page 14, Your Lordship.
Page 40,
14.
14. Ah. Wrong number plate.
Actually.
What do you say? Huh?
Well, he is not the owner. Ultimately, he appeared, my lord, statement also recorded. Statement also recorded.
Then we'll make it absolute. He appeared.
Appeared, my lord, his statement is, it is, my lord, 17-1-26.
Statement is of?
My lord, 17-1.
Then why is he moving an AP on 18-2?
Yes, my lord. But his statement, my lord, no, my lord, his statement is here, but my lord, that is not, date is not that, my lord. The pen orang, the statement is here, my lord. Date is not mentioned, my lord. Date is not.
So we'll allow it.
Well,
the Learned APP has submitted that the case diary has been received and it reflects the statement of the petitioner to have been recorded.
yes.
We'll stop. In such view of the matter, the status of the opinion that the further custodial interrogation
No,
of the petitioner.
Custodial interrogation.
Huh?
Custodial interrogation. AB, my lord.
Don't understand.
My lord, first, like that, my lord. Further custodial interrogation.
No, I'm saying that this court is of the opinion that further custodial interrogation will not be required.
Sorry, my lord.
Therefore,
Sorry.
the prayer of the petitioner for grant of a pre-arrest bail is accepted in the event of the arrest of the petitioner in connection with Behali PS case number 2 of 2026 under section so and so. It is directed that the petitioner shall be released on bail on furnishing a bond of rupees 15,000 with two sureties of the like amount to the satisfaction of the investigating officer. AV disposed of.
I'm being at item 47. Lordship, copy was served on Mr. Boro. He has submitted his revision. Lordship, may fix on Wednesday or Thursday. I'll obtain instruction because matter relating to Silchar branch.
It is only with regard to 47 and 48, nothing else.
Lordship,
The entire records are here. We have waited from,
yesterday, Lordship, my learned friend informed me. And I make.
we have waited from
Lordship,
27
earlier
to
notice was served on Mr. Miller.
then 5th of March.
Yes, Lordship, I have gone through all the orders. Lordship.
Every day we have to explain, sir. That
No,
is the
Lordship, what
difficulty. The cause list is showing DRI.
Yes, Lordship.
None is appearing.
Lordship, what happened? Mr. Minal Boro was appearing in.
His
this
name
case.
is not there in the cause list. There, it shows as a standing counsel DRI.
No, Lordship, interestingly, copy was not served on me.
Hmm.
So, Lordship, there are 3 standing counsels in the department. Lordship, may take one on Wednesday, Lordship. In the meantime, I'll.
Your only ground is that 47 and 48 is not there.
Other there, Lordship, there is no recovery from the vehicle. And other.
No,
ground is-
otherwise you are on the 47 and 48 of the.
No, you mainly on these two ground. Other
And
ground is there.
Other grounds are there, but 47 and 48, if that goes, then we'll go to the other grounds. If 47 and 48 are there.
I am.
If it is not there,
Lordship,
then we did not go into the other part of it.
judgments are there, Lordship. Lordship has already passed similar orders. Lordship, may take one on Wednesday.
Please, Mr. S.C. Kyal appears in the matter today. Mr. R.K.D. Chaudhary has also and had also appeared as a matter of abundant caution after the order dated 5/3/2026. List this matter again on
Wednesday, Lord.
11th of March, allowing Mr. KL to go through the case records. The learned counsel for the petitioner shall supply a copy of the petition upon Mr. S.C. KL during the course of the day.
Lord.
Thank you, sir.
All right.
Huh?
I marked the pages.
Okay.
23.
On 11th.
May it please your lordship.
Yes, sir.
Lordship, regarding, they have to confirm, Lordship, whether charge sheet has been submitted on Lordship 193.
Not yet received. Not yet received, my lord.
Not
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 yet
submitted.
received, sir. After some time, my lord, we have convened to our officer.
You are awaiting.
My lord, yes.
After some time.
May I, please, Lordship, I have another item in court number 25, Lordship. in
We'll
this-
just find out if the charge sheet is not there. We'll allow the bill. If the charge sheet is there,
TCR
then we
call
will,
for it.
then we will call for the TCR. Okay.
All right.
7.
Hmm.
27.
37.
37, my lord.
Case diary was called for, Lordship. And
Huh? Why does it say same accused?
Manka sir, no?
Hmm?
Manka sir, ten.
Did you serve a copy on Ms. Bhuya?
I apologize for that, Lordship. I was under the impression that Lordship direction was given to the registry, Lordship. Lordship, I will serve the copy today itself, Lordship. I have not checked the order, Lordship. I am sorry, Lordship.
Then we'll take it up on the 11th of March.
11th of March.
Without her presence, we cannot proceed.
Yes, Lordship. And during the course of the day, Lordship, I will furnish the copy.
At the request of the learned counsel for the petitioner, list the matter again on the 11th of March, allowing him to serve a copy of the bill petition on the learned amicus curiae. Yes, what were you saying, Mr. Parashar?
Yes, my lord.
11th of March?
Case diary is also not there,
Yes,
Lordship.
the CD.
The case diary is also awaited. The APP shall endeavor to have the case diary on the 11th of March.
highly obliged.
Yes, 38.
38 also, my lord, to be, my lord.
Hmm?
May I plead your guilty?
Hmm?
So this is the matter the doctor, he has written some
Ah,
words
ah.
English.
Charge sheet submitted, my lord.
Huh?
Charge sheet submitted.
Charge sheet
Yes, you
submitted.
get
No
submitted.
fear of arrest now. The learned APP has submitted that the charge sheet has been submitted.
Right, CS number
Accordingly-
79/2026, dated 26/2/26.
Accordingly, the question of the petitioners being arrested for investigation does not arise now. Petitioners at liberty to approach the trial, the jurisdictional court.
Till my appearance, my lord.
Huh?
Till my appearance before the court, my.
No, we have said that now there is no question of your being arrested for the investigation.
Investigation for it is over.
Gone. So now they don't have the authority. We do not want to be too elaborate in some of the orders.
Appearance, my lord.
So, petitioners at liberty to approach if and as and when summons are received.
Okay.
Disposed of. Yes, that lot of boys were involved. Is it not? Lot of people were involved in.
Can you see the FIR, please, Lordship?
CD not yet received, my lord. CD is in Lakhimpur court, my lord.
Eh?
CD is in Golpara court because of that CD not given to us, my lord.
Gwalpara court?
My lord. Before the line in the additional district sessions as Golpara.
Lordship,
See, other persons who were taken into custody have all been granted bail
yes, Lordship.
because nothing implicating against the arrested persons. These are not even named in the FIR, if I'm not wrong. He is not even named in the FIR.
So, my lord. Service report also not there.
We'll go through this. Go through this. Kindly ask if the CD has been called for in the Gwalpara court in connection with any of the two petitioners.
My lord, we have received a written signal from the police, my lord, that the CD could not be produced because it is pending before the additional session judge.
That is what we want to know, whether it is these two petitioners who are before the session judge and the High Court also. If not,
Yes, if not.
this order
Yes.
where bail was granted, we'll allow them an interim. They'll go and appear. Then we'll have the full CD call for.
And sometimes maybe in here also, there also. my lord.
Therefore, we go and just find out these two names.
My lord.
We'll take it at 2. We'll take it up at 2.
My lord.
Find out these two names.
Again,
For which, is it against these two persons that the CD has been called for? That is all. Otherwise, we'll grant the interim today. Huh?
May I please your lordship?
Yes, madam.
Lordship, there has been a delay of 1041 days in filing this appeal, which has been duly condoned, my lord. And the copies are being served to amicus curiae.
Your Lordship, I haven't received the copy.
Supply her copy, ma'am.
Lordship,
wasted this land.
Did you serve a copy on the?
yes, Lordship. On the last date, it was listed.
Have I
Huh?
seen? Last date is in the
22.
She says she has not received. You must have got a receipt. Do you
Yes.
have a receipt copy?
Hand to hand, my clerk.
No, your
has
Lordship,
given
I
it.
was appointed on the 20th of.
And they on the same day
That day only I have served.
someone has served. The clerk says,
Otherwise, I would have signed.
give her a copy.
Okay, Lordship, during the course of the day.
Of both the IA and the criminal appeal.
Lordship.
This is an appeal from jail, is it not?
Yes,
It is an appeal from jail, so
legal service.
unless you have some very big objection, we'll delay the control, listen the appeal. We'll have it on the 13th of March.
Yes, Lordship.
The counsel for the appellant
Smithy.
has undertaken to serve a copy of the interlocutor application and the criminal appeal upon the learned amicus appointed by the court. Release this matter again on 13th for consideration.
Lordship, pardon? Which day?
Give her a copy. We'll have it on the 13th. We'll consider the continuation of delay. Try to take up the appeal on the next date.
Highly obliged, Lordship. 1041, yes.
Please, Lordship. Lordship, in this matter, Lordship, service has been complete, Lordship.
Huh?
Service has been complete.
Pardon?
52. Lord, none appears from their side, Lordship. Yes, sir. Transfer petition. Lordship,
Although service of notice on the respondent number 2 is complete, there was no representation for the respondent number 2 on 16/2/2026. There is no representation today also. Full stop. We'll have to appoint an amicus in such view of the matter. Mr. Ujjwal Soikia is appointed as an amicus in the matter. Learned counsel for the petitioner shall serve a copy of the TRP criminal upon the learned amicus. List the matter again on 16th.
Also, we will file one additional affidavit. There are some development in the Dimahasa case, Lordship. We will file one additional affidavit.
The petitioner shall be at liberty to file additional affidavit bring on the recent developments in the matter.
53.
Yes. What is this? 50. This is item 50. 53 is connected with 52.
No, Lordship.
No. 53 is connected with item number 18.
Item 18 continue. Yes,
18 already.
18 key order limit.
18 already gone.
Modification of the order. Key modification lage. Under prayer to key actually.
Same name, Malak. Item number 18.
Just a minute. Oh, he wanted a correction. It will item 53, no? Item 53. In view of the order passed today in
31, no?
item number 18, huh? So this I has become infructuous. I closed.
Timing 31 Timing 31 in this case, updated CD was called for in the meantime on 19/2. Petitioner number 2 was given interim manner. Now, updated CD for updating the CD it was not taken back, and CD is up to 10th of January. So interim granted on 19/2. Whether he has appeared or not, subsequent development is not in the CD Malak. Already.
Have you appeared?
We have appeared, Lordship.
You have appeared?
Yes. Also, Lordship, FSL was called.
Huh?
Also, FSL was called.
Call for the updated case diary. Full stop. Along with the FSL report. The interim order passed earlier in respect to petition number 2 continues.
Fiction 18.
18th of list again on 18th of March. Yes.
Request your lordship to take up item number 9 at 2 PM. Your Lordship.
Okay.
I'm deeply obliged.
I'll just come back in 2 minutes. We'll have your matter at 2.
I'm deeply obliged.
Yes, sir.
The lordship has the last order minute. Passed by.
Ah.
Of course, my name is not.
Yes, sir. CD available or not? Eh? Huh?
Page 21, the second last paragraph. The last paragraph. That still remains operational. Case diary, the paragraph. Materials available in the case diary. I'm only on the case diary. No criminal cases made out.
Till the grant of the pre-arrest bail, no case was made out
And I'm on
against the
HR.
petitioner.
And I'm on HR. Their insurance claims have also been rejected. Nothing remains. And they are not to contest before this court also. They know what is happening. A failed business, a misled group.
The loan which is said to be now not repayable is an insured loan.
Insured.
Then they'll get back their money.
The storm, act of God. It was act of God.
That the chicken thing.
Yes.
Huh? The chicken thing, yes.
And if I may submit in all fairness, Lordship may please to indicate the act of God in the parties here. That everyone calls quiet. It's a quietness is given to that. Otherwise also.
You want to go through it?
Yes, ma'am. I have gone through the FIR, but regarding CD was called for, but CD.
The CD has not come.
No.
Till the time of the pre-arrest bill, that is on. What was the date of that order?
26th of April 22.
22.
21.
Nothing is there. Should it continue against him?
What is the stage? Nothing has been informed. Twice we have sent signal on 9/1/26 and again on 27/2/26.
The anticipatory bill was for 4 persons.
And now 3 are before the court. Heard Mr. S. Bonik, learned counsel appearing for the petitioner, also heard the learned APP. Mr. K.K. Parasha, the last order of this court had recorded that on failure of the production of the case diary, the matter will be taken up on the basis of the records available. Full stop. In this criminal petition, the petitioner has prayed for washing of the FIR number 169 of 2021, which resulted in Thelamara PS case number 169 of 2021 under sections 420/406/468 of the Indian Penal Code. Full stop. Were you given any interim protection?
Yes.
By which order?
No. We were on bail by this order.
No. Interim protection to the extent of keeping it in abeyance or something. No.
But I've checked the 34 is there.
The learned counsel for the petitioner has drawn the attention of this court to the order dated 26/4/2022, passed by this court in AB number 3760 of 2021, where this court after having gone through the case diary, had observed that no criminal case is made out against the present petition, against the 4 petitioners in the bail application, 3 of whom are before this court in the present criminal petition. The learned counsel for the petitioner has submitted that a loan was sanctioned and credited the money into the bank account of the NGO, so that the NGO could provide materials for the informant and other persons to run the business of, what is the business called?
This, we have put that.
Business of so and so. We'll find out and we'll tell you. Business of
6 paragraph 4.
Huh?
Page 6 paragraph 4 and 5. We have detailed it.
Poultry, honeybee, etc.
To provide the bank account of the so and so of the bank account of the petitioner NGO of the NGO of the petitioners to provide training and materials such as poultry, fish farming, and honeybee keeping for livelihood among the villagers. However, due to an act of God, after the entire after the NGO had supplied the basic materials,
That is on page 27, paragraph 4, entire thing detailed.
Page 20.
Of the additional affidavit, page 27 and 28, everything detailed.
You strike out that last line. You said that after the informants had availed the bank loans from the UCO bank, and the bank had released the money to the NGO run by the present petitioners, and the informants had purchased the goods and materials through the NGO of the petitioners, and their businesses were operational. However, due to an act of God, namely a unprecedented storm, the business of the informants had suffered, and they had lodged the FIR, claiming that although the money had been disbursed to the NGO firm, to the NGO, to the NGO, the informants were required now to repay the loan, full stop. The learned counsel for the petitioner has submitted that the loans had been insured and the liability would not fall upon the informants. And moreover, it was in the way of business that the loan amounts paid for by the informants had been disbursed to the NGO run by the petitioners, since the expenses in setting up the business had to be done through the NGO of the petitioners, full stop. In such circumstances, it is the submission of the learned counsel for the petitioner that when the then available CD did not indicate any criminal activity of the petitioners in having the loans disbursed or in being or in any manner being involved with the repayment of the loan,
or in the occasioning of the storm. That's a root cause.
The informants would remain liable to repay the loans, and in case of their failure, since the loans are already insured, the informants would be entitled to avail such insurance to protect their pecuniary loss, if any, full stop. This court has gone through the entire records available and is of the considered opinion that the petitioners have not, neither the FIR nor the CD as available in the year 2022 had revealed any criminal activity relatable to the petitioner's hearing, full stop. In such circumstances, this court is of the considered opinion that no fruitful purpose would be served allowing the trial of the petitioners with regard to the FIR dated 9/11/2021 lodged by the informants. Full stop. This court also notes that despite service of notice, the informants have not appeared before this court to contest the criminal petition. Full stop. In view of the above, the prayers made in the criminal petition are allowed. The FIR number 169 of 2021, Thalamara PS case number 169 of 2021, corresponding to GR number 3958 of 2021, is accordingly interfered with and set aside by this court. Any process drawn up by the jurisdictional court for trial shall also accordingly stand quashed. Criminal petition disposed of.
My lord, may mention that in spite of twice signal CD not received by us.
Ekdam upor likhi dibo. Today also, despite the aforesaid observation on the order dated 26/2/2026, the CD has not been placed before this court.
Sorry, insofar as sections are concerned with the police station, 34 was.
34 would also be there. Whatever is there in your.
No, I saw that. In the prayer, it's 34 is there. In the AJR, it's there, 34.
To page 1 and 2 jikita ase, Thalamara PS case it good.
Deeply.
Yes, sir.
But this is a criminal petition, my lord, invoking inherent jurisdiction of this honorable court. Basically, my lord, paying for setting and quashing of the impugned order dated 2/6/2023, passed by the learned Chief Judicial learned Magistrate, my lord, CJM Kamrup, my lord, whereby cognizance of the offense was taken and mechanically the summon was issued, my lord. First, my lord. There again, my lord, my another prayer, I'm seeking, my lord, quashing of this police case, my lord, FIR and the charge sheet, my lord, as well, my lord. This is, my lord, on 3 grounds, basically. First, my lord, this is a case, my lord, where there is a bar of section 195 CRPC will come. Because, my lord, the allegation in the FIR against me is that I used one forged document while procuring a anticipatory. That was the allegation against. So the respondent, he lodged FIR against me before the Latasil police station, and investigation was carried out. In the charge sheet, it is shown that this forgery was done inside the court premises. This is what the finding of the police. And their official report, there is no official report supporting the allegation also.
Okay.
And in the so far charge sheet I have seen, my lord, there is no any witnesses statement even, nothing is there. Now, my lord, once, my lord, this allegation is that, my lord, that document was used for procuring the order from this honorable court, then, my lord, this is an offense, my lord, affecting the administration of justice.
Yes.
Then 195 automatically comes. Then 195 says that private individual cannot file the FIR. Only the complaint can be filed. Read with section 340 of the CRPC and 195. Then in that situation, only the court is only competent, my lord, to file to undertake the necessary inquiry under 340. Thereafter, it finds that there is matter to be required to be investigated further, then complaint can be filed by the court only, my lord. This is what the, my lord, scheme of the CRPC. So, but in the present case, what the investigation this police has done, this is, my lord, there is no such any complaint from the court, my lord. Only FIR from the private respondent, my lord. He is having a, my lord, so many checkered history between us. As on today, he has filed more than 4 cases against me. So many issues are there, my lord. Now, the FIR was filed. Now, my lord, when the FIR was filed, the law says, my lord, of course, investigation can be done. But when the charge sheet was filed, learned magistrate ought not to have taken cognizance considering 195 bar, my lord. Because law says that private FIR is not maintainable and cognizance cannot be taken on the basis of the FIR, my lord. So this is one ground. Another, my lord, ground. My lord, leaving aside this technical aspect of event, my lord, when we take this charge sheet, my lord, it says that
where is that particular forged document? Is it there on record in this case?
Here, my lord, I have used, my lord. My lord, kindly turn to page number 24. 25 is the, my lord, 24 is the type copy. 25 is the, my lord, this lease agreement document.
Just a minute. Page 20?
25, my lord.
25. Huh.
My lord. So, my lord, basically, before this, my lord, some relevant facts I just like to, my lord, apprise, my lord. My lord, what happened exactly is like in the year 2000, it was in the year 2016 and 17, my lord. That, my lord, I was awarded some contract work for the construction of road. I'm basically a contract for Arunachal Pradesh. Then I wanted some excavator, more machineries. So at that point of time, this private respondent, his 4 excavator were already there. That was working under some other contractor. So somehow we came to know each other. Then my case is that this lease agreement was executed between us. So thereafter, my lord, as per this lease agreement, money has been paid also. That is on the record event. 14 lakhs advance amount was paid even, my lord. But subsequently some development happened. What happened like that this private respondent, it seems like could not pay this salary or all these things of some of his staff. Then they started seizing this particular excavator. There is a record also showing, my lord, police seized the vehicle, excavator, and at the instruction of the private respondent, it was handed over to some person. There are certain allegations. And thereafter, the private respondent files a FIR at the Dibrugarh. Now, not there, because as per is that he went there, but somehow he was mishandled or something there. In the Dibrugarh, FIR was filed using rather a forged document by the informant saying that I entered agreement with the mother of the private respondent.
Okay.
And my mother is not the party, has never filed any complaint against me. And at that point of time only, when FIR was filed, I came to know this excavator were owned by the mother of the private respondent. Now, what happened was, thereafter I approached this honorable court. I filed the AB, my lord. Then in that AB, this lease agreement was used, saying that the matter was of the commercial transaction.
Yes.
And considering that aspect, this honorable court, because the dispute arising out of the commercial bail, granted the bail. Subsequently, my lord, for cancellation also, IA was moved. Recently, this has been rejected, dismissed, my lord. And there also same allegation. During that bail time also, it was alleged that this is a forged document. Now, my lord, this is a just relevant facts. Thereafter, then this Latasil police case, FIR was.
Where is that FIR?
My lord will find. His number. Page number, my lord, 57, my lord. Type copy, my lord. My lord, may I read?
Okay.
Now, basically, my lord, even on merit, my lord, if we see go by the charge sheet, all those things, my lord, then my case is that even on merit, there is no prima facie case whereby, my lord, cognizance could have been taken. Number one, my lord. Another point, technical aspect, my lord, that 195 bar is there, my lord, that cognizance could not have been taken at all by the learned magistrate, my lord. And even, my lord, issuing summon, my lord, this impugn order, my lord, it reflects, my lord, that the judicious mind has not been exercised. Mechanically, someone has been issued, but the law says, my lord, some sort of, my lord, exercise has to be done to show, my lord, whether this is a fit case to proceed further with or not, my lord. These are the, my lord, basically three grounds, my lord. On, my lord, this charge sheet, my lord, even if my lord says, my lord, this official support report is not there, saying that, my lord, and, my lord, there is no witness, there nothing in the, my lord, investigation. My lord, very interesting. What is the finding, my lord? My lord, will I come inside the old court premises and I will force the document and I will use in the anticipatory application, my lord? This is the finding of the police, my lord. And on that basis itself, my lord, then this law comes, my lord, there is settled proposition law, my lord, that under such circumstances, private affair is not maintainable at all, my lord. And may I take to, my lord, 161 statement? I also lodge one case which is pending now against the private respondent, my lord.
So that original agreement copy is nowhere to be seen.
Original, my lord, it is it is not there, my lord.
You produced it before this court. It should be with you.
But I came subsequently in this case.
No. When I say you, we mean the petitioner.
Petitioner.
It has to be with him. Because the forensic was done on the photocopy of what was available before.
This Duimuk police case, I lodged one FIR against him. The Duimuk police case is under investigation. Most probably, my lord, that document might have been with this Duimuk police.
Wrong statement, lordship. Absolutely misleading statement.
We'll
To his usual cunningness, he is misleading this court.
We'll come back to you. We listen to one counsel at a time.
Should not mislead being a student of law. Doesn't suit him.
My lord, very unfortunate. All the time we have been contesting all the time. Only one language he uses: misleading. This is the highest vocabulary he has with him all the time.
And so, I have proved it, lordship. I have proved it on all the occasions.
My lord, may I continue, my lord? My lord, 161 statement of private respondent when he was arrested in Duimuk police station. May I take, my lord, page number 53?
53.
My lord, and accepted. Of course, this is 161 statement, my lord.
Yes.
May I read, my lord? This is the 161 statement of the private respondent, my lord. In that case, where he was arrested, because I also lodged FIR saying that because my allegation against him that he forged my signature and he filed the case in Dibrugarh using my name, my seal, my signature, and against him. That case is still pending for investigation. So I got the order for further investigation. Matter is still under investigation. In that case, he was examined. My lord, this is his this my lord statement, my lord. On being examined, I am to state that I have 5 members of so and so, numbers of so and so. This machine belongs to my mother, Srimati so and so. I am looking after her machine. In the month of January, I have been approached by MS so-and-so joint venture company. They want excavator for hire basis. On their request, I agreed and given the machine to MS so-and-so and accordingly, they have taken the machine after agreement for the period of 1 year. After the expiry of the agreement, I have given 4 number of so-and-so on hire basis at the rate of rental charge so-and-so per month. I have never told him that the machines are actually belongs to my mother. He has given me rupees 14 lakhs as in advance payment. Then after I have never visited to the site of Tagung Neri to see the machine, although Tagung Neri called me several times to visit there at Mariang. Then after about 1 year, I have falsely lodged FIR against Tagung Neri at Dibrugarh police station, alleging him that he had physically assaulted me, and accordingly a case was registered at Dibrugarh police station. I have also submitted a document letter paid of Tagung Neri to the Dibrugarh police station, citing falsely that the agreement made at Dibrugarh. I admit here that I have committed wrongs towards Tagung Neri. If I happen to meet him, I will beg pardon. The question, why you have lodged FIR against so-and-so? It was done on the advice of my advocate to get back the Pockland from Tagung Neri without paying repairing charge. Where do you keep the question document letter paid? At my Kolkata office, which is now so-and-so and so-and-so. This is when he was examined under 161, my lord. So Dibrugarh police case, my lord, all this manufactured document, I never, my lord, met his mother, my lord. As on today, even till today, my lord, I have never seen her mother, my lord. This mother, otherwise, my lord, mother would have filed the FIR, mother would have pursued the matter, my lord. It was private respondent only, my lord, through whom this lease agreement was executed. I took the excavator. Subsequently, my lord, some liability he was supposed to pay me. Some issues cropped up, my lord. Then he lost the FIR, and somehow he, now as on today, thereafter he managed to get 2 excavator back. And one of the excavator is still siege under Dimuk police station, and one of the excavator is still lying in the jungle. That's one, it was not in the working condition. Reason being, my lord, now, my lord, private respondent, my lord, these are the issues, my lord. Of course, the private respondent will make another allegation, but the issue here, my lord, even if suppose this allegation against me, my lord, now, my lord, it has to be done in accordance with law. Because, of course, my lord, we cannot come out rightly now that who has forged the document, who has not forged the document, right? So, it is the allegation against me that I have forged the document and used in the bail application. Now, what is the procedure for that one? There is a procedure, madam. Procedure is that bar is there under such circumstances. It is the court only, my lord.
Show us the provision.
195. Read with us.
One
195. One. Then small b, Roman 2, my lord. 195. 1 small b, then 2, my lord.
So you're saying that since The offense is alleged to have been committed in respect of a document produced or given in evidence in a proceeding in court. No cognizance can be taken except on the complaint in writing of that court,
Then proceed.
or by such officer of the court as that court may authorize,
Yes.
or some other court to which that court is subordinate. So either the complaint should have gone from the High Court itself,
My lord,
or it should have been done by the trial court,
my lord, my lord.
where the document was in issue.
Document was used here, not in the trial court.
So it has to be only by this court or by the Supreme Court.
My lord, then then inquiry has to be made under section 340. CRPC. Procedure is there.
P40. In respect of an offense in which case where that court has neither made a complaint or the making of such a complaint be accepted.
So, my lord, my submission is that it's not something I am.
No, this should not have been an FIR. This should have been a complaint or a application made to this court.
340. Then inquiry has to be done.
Huh.
Then after that inquiry only, if court finds that there is a case of like prima facie satisfied, my lord, then only after, my lord, then subsequent action has to be followed, my lord. It is not something, my lord, straightly filing FIR or complaint is not like. First, inquiry has to be conducted. So it's my case, my lord, I am not shying away from resisting that no investigation should be done against. This is not my case, my lord. Let it be investigation then. If it is so, then whatever the consequence, petitioner will go through it, my lord. But the question here is, my lord, this is
whether
not
on
the
the mere charge sheet the trial court should have taken cognizance. That is what
cannot be taken cognizance. There is a part. Otherwise, also, my lord, this apart from this technical aspect, on material, what are the materials to come to the prima facie for issuing summons? This is also, my lord. Yes, what is the material collected?
what we find is that the FSL report, the entire FSL thing was done on the basis of photocopies.
Photocopy done, my lord. Then even
now, if it is a photocopy, the handwriting can never be
this is
ascertained.
Part of the investigation they should have done, my lord. They could have done whatever they could have done from against me. They could have done, my lord. So question is whether, my lord, whether this is the material sufficient. These are the charge sheet and the materials. Another aspect, my lord, whether it is sufficient to proceed, my lord.
Whether it is sufficient or not, for that we will, for the time being, leave it to the wisdom of the trial court. We will not go into that part. We will not express our mind on that.
Well, then two grounds, my lord, if not married, if my lord is not, two grounds. Apart from this 195, my lord, there is, my lord, that issuing someone. My lord, may I take to this?
No, 195, unless the 195 we are for the moment.
Yes.
We will, of course, go into the record to see whether there was a complaint at any point of time against you by any court or not. That we have to see.
Yes.
So that and the 340 part, very well. Next, what do you say?
My lord, this kindly turn to page number 84, my lord.
84, yes.
Well, this is the order whereby which cognizance was taken. Case is received so and so, so and so. On perusal of it appears the charge sheet was submitted against so and so, alleging issue summons to the accused person, papers so and so and so and so. Now, my lord, law says, my lord, mechanically in this manner, my lord, someone cannot be issued. Some exercise has to be then. What are the materials, my lord, that has been, my lord, relied, my lord, peruse, and what are the these incriminating materials are available against me, my lord. My lord, someone is not something. It has been said is a very serious thing. summoning a accused, it is not something very casually it cannot be done. That the apex court is saying is a very serious matter, my lord. Putting
Yes.
someone to come to the court to face, then at least, my lord, at least first court, learned honorable court should have ensured that there is a material calling a person to face the criminal trial, my lord. So that is another ground, my lord. So, my lord, in that, my lord, some judgment I have so far 195 is concerned. Table. 1998 together. 2004. My lord, these three judgments are basically on this 195, my lord. And there is a judgment of a constitutional bench also. There was some divergent view also. There was subsequently constitutional bench also. I'll start from 1971, my lord. 1971 to SCC 376.
Yes.
Patil Lalji Bhai Sombhai, my lord. Para 7 and 10, my lord. Paragraph 7, my lord. It has entirely discussed about what is the object, my lord, why 195 has been enacted, my lord. Basically, my lord, that what happened, my lord, when the private parties are involved, so, my lord, they can keep on filing several cases against each other, raising so many. So that's why I said that whenever such documents are used in the court, so that the private parties should not take chance of opportunity and they should not keep on filing multiple cases against each other. That's why this is the object, and the most fit body would be the court under which the document was used, my lord.
Yes.
So this is this 7 and 10, my lord. Thereafter, my lord, this 1998, my lord. This Sachida Anand Singh so and so, my lord. There are 7, 8, 9, 10, 11, and 12, my lord. 12, my lord.
Just a minute. You said 7, 8, 9,
10, 11, and 12, my lord.
Okay.
My lord, 11, I will just read 11, my lord. 11 and 12. The scope of the preliminary inquiry envisages in section so and so is to ascertain whether any offense affecting administration of justice has been committed in respect of a document produced in court or given in evidence in a proceeding in that court. In other words, the offense should have been committed during the time when the document was in custody so and so. 12, my lord. It would be an strain thinking that any offense involving forgery of a document, if committed far outside the precincts of the court and long before its production in the court, could also be treated as one affecting administration of justice merely because that document later reached the court records. Here, my lord, it is not something, my lord, every document that is used, forged document that is used, it is
if
not
the
something-
forgery is done on a document which is available on the record.
That is one thing. Another aspect, my lord, that has been deliberately forged only for the purpose of obtaining order from the court or playing fraud from the court and thereby affecting the administration of justice. My lord. My lord, it is suppose some document, forged document, my lord, which has nothing to do with that thing. I use it, my lord. Then this clarification says that bar will not come because those documents long time back before production of the court that was forged already. So separate FIR is permissible. So not necessary that every document, my lord. Now my case is completely different. What is the finding of the police, my lord? That it was forged inside the precinct of the court, my lord.
This issue.
Yes, my lord. Charge sheet, my lord. My lord, this charge sheet, if I, my lord, take to the charge sheet, my lord, this, my lord will find this, there is a, my lord, sketch map of the place where the offense was allegedly done, my lord. And the map is saying, my lord, whole building and the petitioner was there, he forced the document, my lord. This is something very improbable and highly absurd. And my lord, I got the matter filed through the learned advocate only, through my advocate only, my lord. And at the most, affidavit was shown by me, my lord. And I handed over the document to the learned advocate, my lord. And how the findings of the, my lord, investigation that I was inside the court premises.
No, probably what they tried to say was that this is the place where it was used. The place of occurrence would be the place where the usage was done.
Yes, yes, my lord. Therefore, my lord, now, my lord, my submission is, my lord, then 2005 judgment, my lord. This is a, my lord, constitutional bench judgment, my lord, affirming the, my lord, this Sachidanda Anand Singh view, my lord, affirming the view taken in Sachidanda Anand Singh case, my lord. Now the issue, my lord, before my lord, is whether this document allegedly, my lord, used so far saying that only for the purpose of obtaining bail, my lord. Now the question before my lord is that, and that too alleging that it was forged inside the precinct of the premises of the court. Now the my lord would see that whether this particular conduct, it falls under the category of affecting the administration of justice or not, and whether this is a bar under section 195 would be attracted.
In case you did not have that agreement,
Yes, ma'am.
it was still the case of the petitioner that those vehicles had been given to you and you did not pay the amount. And when he went to ask for the amount, you misbehaved or you threatened him or you did whatever you had to do. Does it still take away that observation of the court in the absence of an agreement that it is a civil dispute? Will it still take away that part?
Right.
Or even without that particular agreement,
Right,
the court would still come to a conclusion that it is a civil dispute?
my lord.
Hmm?
And, my lord, considering the nature of the case, facts of the case, my lord, then definitely, my lord, this was a case, my lord, where I paid 14 lakhs money beforehand. There was a transaction, my lord. So their agreement process that, my lord, all this repairing charge, everything ought to be paid by the owner. Now the very interesting, my lord, this entirely, my lord, this, definitely, my lord, the entire issue is of the civil nature, because, my lord, suppose, my lord, if even, my lord, this so far mishandling is different thing, my lord, but so far recovery of the vehicle, suppose this is his case also, my lord, that on lease it was given, my lord, meaning the possession was taken lawfully, my lord. It was not, my lord, forcefully, possession was not taken, my lord. This is his case also, my lord, that there was a agreement, but his case is saying that I made an agreement with his mother, which I say that I have never made his mother, my lord. Now he has forged the document and he filed the Dibrugarh police case, and thereafter, my lord, in that circumstances, my lord, bail was granted, my lord. And my lord, recently, my lord, his IA has been dismissed, especially saying, my lord, so far this allegation, this fraud, my lord, this part, my lord, was argued during the hearing of this bail plea AB also, my lord. That was one of his ground also, my lord. But this honorable court, after hearing the parties, made an observation, this is of a civil nature, my lord. But now the issue is of, my lord, now very serious allegation against me is like whether this document after forgery, I used to obtain the order. This is a definitely, my lord, very serious allegation. Then, my lord, my case is that if it's so, this is the allegation. My lord. Now, inquiry, this is the case where administration of justice, this 195 bar will attract. This is my case, my lord. Then once this is attracted, my lord, then after inquiry only, my lord, this a prima facie opinion can be made out, my lord, that whether FIR should be filed by the appropriate competent authority, my lord. It is not something, my lord, the private individual, but my lord, now we are not in good terms, my lord. For now, as on today, he has filed more than 4 or 5 cases against me. So I have also filed 1 cases against him. So of course, we'll keep on giving each cases against each other, fellow. This is what exactly they, only because arising of that issue.
Okay.
Now, my lord, and another aspect, my lord, this the manner in which cognizance has been taken, my lord. This for this, my lord, judgment. Uh, 2021. 2021. 5. SCC online 20. 435. 435. Yes. Zero. 6. My lord, 2025 SCC online, SC 208, my lord. Para, my lord, 6, 8, 9, and 10, my lord. Yeah. Beautiful.
It was staple correction. Staple marks. Staple to arise, staple to mediate. Yes, what is this?
My lord, that is also for, my lord, some issuing someone, my lord, not a, my lord, case, it should not be done casually, my lord, on the same point of law, my lord. Now, this one, my lord, is for, my lord, when investigation carried out, especially for forgery, my lord, there is no FSL, no other material supporting the allegation, my lord. In that case, the honorable apex said that there is not a fit case to quash, my lord, not to proceed ahead with the case, my lord. This is that case, my lord, especially for forgery, my lord. This particular, my lord, will find paragraph my lord, 32, 33, and 34. 42, 32, 33, and 42, my lord. Then, my lord, this issue, that's 2023, 8 or 2025. This 2023 8, my lord. This para 9, 10, and 11, my lord. This saying, my lord, just to show, my lord, when there is, my lord, something, my lord, multiple cases from against each other, parties are given, my lord. Then court required to need to go against the allegation more seriously, and we have to read between the words also, my lord. Because, my lord, only allegation is not sufficient, my lord. So he said that I fought. But after investigation, what is there to substantiate this allegation? What is there in the charge? Nothing is there. Only verbal allegation, my lord. My lord, then 2025, my lord, SCC online, 263, my lord, and said that, my lord, filing of charge sheet, subsequent process, my lord, this is not a bar, my lord, because 482, my lord, knows this is something, my lord, to secure the ends of justice, abuse of the process of the law, my lord, that this honorable court has, my lord, jurisdiction, my lord, considering the other facts and circumstances of the case, to quash the proceedings, my lord, for that purpose, my lord. Now, my lord, with this, my lord, basically, my lord, I'll just summarize my, conclude my case. Because, my lord, allegation is there, my lord, so far. If it is, my case is that let it proceed as per the law, my lord. If it is the allegation. Now, two way, my lord. Suppose, my lord, if this honorable court says, my lord, this is the case where 195 bar will be applicable. If this honorable court finds come to the conclusion, then definitely cognizance is bad in law. It has to go. Now, suppose, my lord, if this honorable court comes to the conclusion, no, 195 will not attend for the sake of argument. Then again, my lord, the question comes, my lord, that where is the materials in the charge sheet to substantiate the allegation that there is a prima facie case of forgery, my lord? And whether this, the manner in which someone has been issued, my lord, whether this is in accordance with the law, this fulfills the law, my lord. So these are, my lord, 2, 3, my lord, points, my lord. So with this, my lord, let the private respondent make the argument. And I'm very thankful to him for giving the patience hearing, my lord, this time. Much obliged.
Yes.
Lordship, I have placed one judgment through the court master now. May we have that judgment? Through an email, I have just forwarded it. Since I am appearing online, Lordship.
What is the citation? Can you tell us?
Lordship, it's not a citation. It was an order passed by this court on 13th of February, where this 195 bar has been discussed in total. And the order is with Mr. Sonar also. When I say misleading, it's wholesome misleading at all counts.
Sir, we understand your anxiety.
Lordship.
And we also understand that this case has to, you would like us to believe your side of the story. But we will just request you one time.
Lordship.
Kindly concentrate on the matter instead of Mr. Sonar.
Lordship. Lordship, we have been enough.
You would not be required to certify the statements made by Mr. Sonar. That is what we would do in the order. What we would request you is show us a judgment which goes contradictory to him. We will appreciate it.
Lordship, I beg your indulgence for having said something which may not have sound pleasant. But the thing is that when some issues have been laid to rest by this honorable court itself, and he has a copy of that, still he tries his best
I again request you to concentrate on your case.
Lordship, I will.
Not on what has been done by either the opposite party or the counsels engaged by them.
Lordship.
That is something we will not take in this court.
Lordship. Lordship, I have placed that judgment before my lords. Is it before my lords? IA 799 of 2023.
Just a minute. Yes.
My lords may please come to just a second. The answer to 195 is clearly given by this court only, Lordship. In page 9, para 17 onwards, Lordship. I don't need to elaborate much. Page 9, para 17, Lordship.
Yes, this court has quoted some judgment of 2005.
Lordship, the law is that 195 1B2. My lords have been shown the provision of 195, but here 195 1B2 applies, Lordship. My lords, we can kindly come to 195 1B2.
195 1B2, yes. 95.
Lordship, what has been annexed with the petition is a certified copy. Let it be very clear, it has not, the original is not in the court. The perfect word is custodial legis. If the court is in custody of the forged document, the court will file a case. But if the forgery is done prior to coming to this court, and this court has been given a copy of it, there is no bar. And that is what this court has written in such a beautiful judgment, Lordship, before my lords. So what he has been trying to mislead, this judicial time is very precious, Lordship.
We would, you use that term once again, sir. We would refuse to take up the matter. There is a dignity of arguments. I have been making requests again and again. Please keep the dignity.
Much.
Please keep the dignity.
Now, Lordship, the provision of law that applies here is 195 1B2. The court is not in custody of the original forged document. The forgery was done prior to coming to this court. And when the word custodial legis is the divine word here, Lordship. When the court is not in custody, anybody can file a case. This has been well spoken in the order of this honorable court that I have just placed. no doubt remains. Now, Lordship, I challenge this petition on the grounds of maintainability before we come to the facts, grounds, and points of law. The petition that is presented before this court has to be tested on the touchstone of maintainability. We are duty bound to come to the honorable court with clean hands. If we suppress facts from this court, play fraud on this court, the petition is liable to be dismissed in limine, imposing exemplary cost and initiation of contempt proceedings. My lord may kindly come to para 5.15 of the criminal petition, Lordship. Those points are much later, Lordship. We have to test it on maintainability. What a fraud has been done by him. Page 13, para 5.5, the last 3 lines, Lordship. It is pertinent to state that the petitioner was never summoned or interrogated by the police in connection with the said case during the investigation. Now, my lords can kindly come to the charge sheet. One more para will be to my lord's notice. Para 5.16 and the last 4 lines. For appearance of the accused and by subsequent order summons have been issued for the appearance of the petitioner. It is, now this is important. It is humbly submitted that the petitioner has never received any summon in connection with the said case till date, and therefore he could not appear before the said learned court. He came to know about the filing of the charge sheet and passing of the impugned order during his recent inquiry about the status of the Tata Steel case. Now, my lords can kindly come to the charge sheet, which is page 80, annexure 15. And my lords can kindly come to page 80A, column number 10, Roman 22. Status of the accused, not arrested on compliance of notice under 41A CRPC. Lordship, is 41A CRPC notice not a notice or a summon? Why did you suppress this fact? Why are you playing around? Have you taken this court to be a laboratory to experiment with lies? How can this petition be allowed, Lordship? Now, further, my lord, he says that I never received anything. A calculated fraud comes up, Lordship. I will show how. I need to press it, Lordship. My lords, he has attached on page 80, which is annexure 15. If he was never summoned to the court and he was never given something, how can he lay hands on an uncertified copy of the charge sheet? Where did he get it from? This is an uncertified copy of the charge sheet, Lordship. Moreover, Lordship, he has suppressed the FSL report in the charge sheet. Why did you do so? Is there not a FSL report in the charge sheet? There is one. The entire petition cannot be taken up for consideration, Lordship. It's a blatant lie. I'm sorry, because truth is bitter and lies are sweeter. And I'm not a student of law, but I can never expect to do such a fraud in this court. Now, to the point of not having an agreement with my mother, Lordship, on 2/9/25, this court ordered all the petitions to be tagged together.
The issue of an agreement with or without your mother is not before this court.
Lordship.
The agreement which is alleged to be forged is something which
of
is
relevance here.
So the
My
mother
lords have
part we are not.
touched, my lords have touched the right chord when my lords asked the petitioner that where is that agreement. Now, my lords, let me explain what is a true certified copy, though I am not a man of law. True certified copy means it's an exact replica certified by an advocate stating that it is as it is in the original. So when you have it with you, you can only have a certified copy. If you don't have it in your possession, you cannot have a certified copy. Now, when my lords asked him, where is the certified copy, he again started misleading. What he suppressed from
Mr. Agarwal.
Lordship, kindly allow me. This is a
Mr. Agarwal, it is 1:10.
Lordship.
Court timings are till 1.
Lordship.
We'll resume at 2.
Lordship.
Yes. Come back at 2. Thank you.
Lordship, the case is that, if I am allowed to make a brief background of the case, because the facts were not entirely before my lords when the case was presented. Lordship, it so happens in the year 2017, my mother enters into an agreement with the petitioner number 1. He gives her 4 excavators on hire. He doesn't pay any rent or advance. Up to this is a civil dispute, Lordship. It has got no element of criminality. Now what happens, Lordship? He disposes and misappropriates and sells them off. Agreement was entered between me, my mother and him in Dibrugarh. Cause of action arose in Dibrugarh. I filed a case in Dibrugarh. Now, if the petitioner was so honest and innocent, he could have come up with the agreement with me and produced it. He did not do so. What he does, he files a counter FIR against me. I am arrested. The FIR meets a natural death and they have been charge sheeted by the crime branch under 182, Lordship. 182 IPC, my lords, I don't need to explain much. Which, my lords, the petitioner's counsel did not present before this court. Now why we are here, Lordship? I file a case when he applies for an anticipatory bail that the petition contains a forged documents copy. 195 1B2 does not stop me from registering a complaint. I have shown that in the constitutional bench of Iqbal Singh Marwa, it has been upheld that if the forged document is not in custody of the court, anybody can lodge a complaint. I lodge a complaint. Lordship can kindly note the year 2019 and the petitioner number 1 is charge sheeted in the year 2023. In this just 4 years, he never raised a whisper that there is a false case against me or there is something wrong with law. He doesn't have any avenues to come to this court or to the police. When a charge sheet is filed, my lords can just see the order that they have pointed out. It's dated 3rd of April, which mentions the next day was 8th of April. Even though he was in knowledge of the order, he did not appear before the court. Now, long time has passed, my lordship. He comes to this court with a quashing petition. Now, lordship will be equally interested to know how this quashing petition progressed. On 15th of May 2024, the petition came up in the motions column. They applied or prayed for an interim stay. The court rejected, said, let the case records come up. On 29th, they took an adjournment. On 21st, an ad interim injunction was given without even hearing us. We were given a copy on 21st of June 2024, Lordship. And then after getting an ad interim injunction in the month of July, when the matter appeared twice, they went off. They did not appear before this court. The matter was heard at length by Honorable Justice Pathak, adjourned for verdict, but the verdict did not come up. So on my prayer for a fresh hearing, it came up this year after 10 months and 2 days, Lordship. When it came up before this court, they again came up for a injunction or a stay. The court refused. Now, the technical point is that by an order dated 19/9/24, my lords can kindly pursue that order. The stay was only up to 27/9/24, Lordship. The order dated 19/9/24, Lordship.
So
it is clearly written till then 27/9/2024, the stay will be there. On 27/9, the matter is adjourned for verdict. It comes up for a fresh hearing. There is no stay. Now, I came up with a vacating petition because when I prayed before this court, the court said move a IA or an appropriate application praying for vacating the stay, which is IA 1308 of 25 before, my lords. Now, I am unable to understand how IA 1308 got separated from this petition, because by an order dated 2nd of September, all the petitions were tagged. So I don't know under whose orders they have been segregated, be that as it may. Now, Lordship, the petition before this Lords is a criminal petition praying for quashing of the case. pending before the trial court. I challenge the petition on the grounds of maintainability on account of suppression of fact. I have shown that he says I was never summoned. The charge sheet says 41 I complied. He says I was never issued a notice. I never got anything. I showed that he has applied an uncertified copy of the charge sheet. Now, my lords, through the court master, I have presented one order of this court passed in IS 778 of 24. If the court master can kindly present it before this court. Lordship, it such happens in one occasion that a person comes to this court with an anticipatory bail suppressing pages of the complaint, which amounts to tampering and a fresh offense under 466. Now, when this petitioner comes to this court suppressing the FSL report, the same law applies. He is also tampering. 466 applies. And if we go by the spirit of this order passed by a coordinate bench, an inquiry needs to be done by the registered judicial that whether he applied for a certified copy, he was given an uncertified copy, and that too without a FSL report. And if at all an FSL report was given, why did he suppress it from the court? Now, my lord, it's very surprising thing for a person like me that an uncertified copy is in the hands of the petitioner. The FSL is suppressed. If we go by the spirit of the order of the coordinate bench, another crime under 466 committed. Let the registered judicial be ordered to conduct an inquiry whether the petitioner applied for a certified copy. If so, was he given an uncertified copy of the charge sheet? And if the uncertified copy was given, whether an FSL was given to him or not. Because calculated frauds are being played on this court and we have to take care of everything. I hope the order is before my lords in IS 778 of 24, lordship.
We have read it. We have read it.
Lordship.
Trial court record. Yes, anything else?
My lords, I would like to place my IA 1308 of 25, wherein I have challenged this petition, if it kindly be taken by my lords.
I number?
1308 of 25, lordship.
1308. What do you want to show here?
Lordship, may I take my lords to page 43, which is an affidavit by the petitioner in the criminal petition when he files a criminal petition against me in Itanagar bench. Lordship, can kindly come to page 25 before coming to page 43, Lordship. I am sorry. Lordship, this is a criminal petition filed by the petitioner in Itanagar bench praying for further investigation in a case which was closed against me, filed by him. Now, my lords can come to the page 43, which is an affidavit. Lordship, para 3, that the annexure annexed to the connected petition are true and correct copies of the respective originals. Signed on 13th of May 2024. In this petition, he attaches the same forged document. So he has the original in his custody. I just wanted to show that. Without having the original in your hands, how can you make a certified copy? Giving roundabout answers will not solve the problem, lordship. Now, my lords, I need to take my lords to page 68 and 69 of this IA. page 68.10, Dibrugarh Police 80,000.
Huh?
Lordship, this surprises every court when I bring it.
Page?
Page 103, Lordship. Page 103, point number 10, Lordship. A statement of expenditure showing having paid Dibrugarh Police 80,000. And this is the reason why Dibrugarh case remains pending since 2018. If my lords come to page 104, they have clearly written it in a typed copy also, Dibrugarh Police 80,000. Now, my lords, I need to take my lords' kind attention to a clear fact. Now, the petitioner says, Lordship, that he never met my mother. And I say that the agreement was with my mother. So, we are antipodes, Lordship. At no point of time we say that we had two agreements, one with me and with my mother, nor he says. Now, my lords can kindly come to page 75. Page 117, Lordship. Page 117 to 121, Lordship. Now, when I am arrested in Doimuk case, I furnished the agreement between my mother and the petitioner. Because that was the agreement we had. And this agreement is found to be true. That is his submission in the court. The FSL report is there, page 121. A case of shifting legal stands. He has never challenged this report, and he is annexing saying the report may be true, there are other facts. How do you get the liberty to play fraud here? And I have been charitable in not expecting a section 35 against the counsel. Mr. Sonar was the counsel in this case, and he had knowledge of everything here. He should have brought to the notice of the court that the FSL report has opined against him. Why did you suppress, sir? Advocacy is not jugglery. Were you not a counsel in this case? Why should section 35 be not invoked against you for misconduct? This report says the agreement between the petitioner and my mother is true, and here it is his petition in the Internagar Bench, Lordship. So when the agreement with my mother is held to be true, the other is false. We are antipodes, Lordship. And now I pray before this court that I have not prayed for section 35 under Advocates Act, but I now pray for it. Mr. Counsel was the counsel for the petitioner in this case also, and he had the knowledge of this. How can he be selective? He is not expected to be selective. Is this a wrong report? Has the copy not been served to you? Have you challenged this forensic? No.
Mr. Agarwal.
Lordship.
Twice before this, we have requested you not to take it up personally against our counsel.
But Lords, if he suppresses facts, what else do we have? He was the counsel in that case. Can he be allowed to let off go? I may not be a student of law, but what this jigglery is going on, Lordship? He just submitted before lunch that he never met my mother. He is annexing an FSL report holding the agreement with my mother to be true. And his submissions are FSL may have opined correctly. There are other circumstances. What does that mean? He needs to explain. He is in person. And this was in his knowledge. He suppressed it from this petition. How can he, Lordship? I have got no personal vengeance against him. But such conduct is not expected from a lawyer. My lord, I have serious objection the manner in which way Mr. Agarwal is making submission, my lord. I am representing the fact as advised to me.
Without commenting on the merits.
Well,
submissions made by both the parties till now have been impressive. But despite our requests, he deems it fit to go ahead. Therefore, not to have a controversy at the moment.
It feels like he's a repository of...
We are restraining ourselves. We will allow him to speak whatever he needs to speak, and we will try to on our own to filter out what is required to be heard. There's something called a freedom of speech.
My lord.
We are allowing that. But then we also have a liberty of hearing what is required to be heard.
Even a regional restriction, my lord, has, I think, accommodated him. I think that has not been imposed.
Yes, sir. Continue.
My lords, at this stage, I will pray for an inquiry from the Registrar Judicial as per the order I presented, that whether the petitioner applied for a certified copy and he was given an uncertified copy, that too without an FSL report, and my lords can after the report have this matter taken up, because it points out a serious offence under 466 for tampering of evidences. And the coordinate bench has taken that stand. I have presented the case.
Did you receive the summons which were given by the, which were issued by the trial court?
Trial court, my lord. This summon, my lord,
Was
not
it
received,
received?
my lord.
Huh?
Not received, my lord. Later on, my lord, when we inquire about the matter, then we came that this matter was, charge sheet was filed. Thereafter, my lord, through my associate only, my lord, we obtained this copy by filing application only. And my lord will see my records and the court's record. I think records of the TCR is available, my lord. So there is nothing, my lord, that I need to suppress any document or something. My lord will be going from TCR only, my lord. And,
Lordship, I think TCR will not put a light on whether he applied for a certified copy and it was provided to him or not. It is not in the TCR, Lordship. Lordship, in 1308, I have limited prayers for vacating the stay which has already died a natural death, so that further investigation can be taken up and the petitioner be directed to produce the original of the agreement that is in question, because he is having it in his custody, so that we can put an end to this entire issue. I think that's a fair enough request to this court.
Yes, who's appearing as the PP? You are appearing for?
Item number 5, Your Lordship.
Item number 5.
Resolution number 2.
And what are you? Who are you in 5?
Your Lordship, Your Lordship, resolution number 2 has expired, Your Lordship. In the last date, I have submitted, Your Lordship. He has expired, Your Lordship. And in connection with that, Lordship, this I may be disposed of, Your Lordship, because it's no service.
Which IA?
195, Your Lordship.
IA এখন দিয়কচোন. Item number 5. Let us first reduce the bundles as much as we can. 1308.
No.
195, Lordship.
195, Your Lordship.
IA criminal 195. What is the prayer here?
Same as the, Your Lordship.
Lordship, the respondent number 2 in the case had obtained anticipatory bail, which was cancelled on 13th of February for fraud on this court. It's a petition related to that. While taking cognizance, the Honorable Magistrate observed something which I presented before this court, and I was advised to file a proper application, and hence this application.
This is regarding the same case where you are, of which you are
Lordship.
seeking a quashing.
Yes, Latashil PSS, yes, yes.
This is regarding the Latasil
This
case.
is the second FIR, Lordship.
Second FIR, there was only one FIR.
Lordship, the prime accused obtained bail. There is an FIR 326/19. This petitioner obtained bail under fraud. There is an FIR 78 of 21, Lordship. Different FIRs, both have been charge sheeted.
Here the respondent number 2 has expired.
Lordship.
So what remains to be directed to be done here?
Lordship, I have a humble submission if my lords allow.
Hmm.
All the applications for bail were rejected for fraud on this court. Lastly, the court cancelled the bail for fraud on this court. So
Which
fraud is not
Which
new
bail?
to this respondent number 2. If he has really
Respondent-
expired,
Sir, again we are asking you, respondent number 2 is at a place where we cannot reach him.
Lordship, please allow me. If he has really expired, let a report be called from the SP because we have no faith on the submissions. Another fraud may be played out.
Where is your document to show that he has
Even the
expired?
documents are unbelievable, Lordship. He has obtained bail on fraud.
A report may be called from your lordship, from the authority, your lordship.
Which authority?
Your lordship.
He will say this man has not died. You will say he has died, and the
Yes.
entire police force will run around trying to find out whether a man is alive or not.
A
You
person
are
with
making a
fraudulent
statement
Yes, your
intent.
lordship.
that he has expired on the basis of what?
That's it, your lordship, we will.
Who has
the
given you that instruction?
Death certificate. Your lordship, the family also we have.
Who in the family? Who in the family has
The
given you
relative
that?
has informed us that the.
Who? The brother, son, father,
the
mother.
brother has informed.
Brother, what is the name of the brother?
Don't know the name of the brother. Your
Then
lordship.
how could he inform you?
Your lordship, to one of the council, your lordship, he
You are appearing on the basis of what? Have you filed your wakalatnama or something?
Yes, yes.
Through whom? Whom are you appearing for?
D. Sharma has stated that that he has expired, your lordship.
What I am asking you is, you have filed a wakalatnama.
Yes, your lordship.
Who signed it?
I signed, your lordship.
Ah.
No. Who is the person?
Oh, Manoj Kumar Bora, your lordship.
Manoj Kumar Bora signed it, and Manoj Kumar Bora, according to you, is not alive.
Yes, your
After signing the wakalatnama.
lordship. No, your lordship.
Prior to signing of the wakalatnama, he was dead. You went into the. No, he's a Bora. You must have gone up. Birbal tried to send someone up, if you remember correctly.
I'm not able to understand. Your lordship, before he
Expired.
lordship, he has signed the wakalatnama, your
Huh.
lordship.
And then
Then prior on the date of 13 to your lordship, before that your lordship, he expired, your lordship. I
he
think
expired before 13 to 2026.
Yes, your lordship. On your lordship, he has expired, your lordship.
Lordship, let a report be called fraud from the SP to Biswanath, Lordship.
At your costs.
If they are reasonable, Lordship, I will be.
It is not about reasonable. They will tell you the cost of going around the house and finding out the report.
Now,
You-
Lordship, if that is a cost for contradicting a claim where a petitioner has been charged with fraud on court, I leave it to my lords. Can this respondent be
Yes.
believed actually?
Tell us.
Your lordship, then on next day, your lordship, I will produce the death certificate, your lordship, of the person. Respond number.
Take down. Miss S. Nazreen, Learned Counsel, had earlier submitted before this court that the respondent number 2, for whom she appears, has expired. The said information was given to her by the brother
Yes,
of
your
the
lordship.
respondent number 2. Full stop on the next date fixed. Miss Nazreen shall produce before this court the death certificate, which is to be obtained from the family members of the respondent number 2. In case of failure to do so, she shall also inform this court the reasons therefore. We'll keep this on 20th of March.
20th of March.
20th of March, huh? What more is pending here? 558 is what we have just heard. What is this 1308 for?
For Lordship, vacating the stay, initiation of contempt proceedings against the petitioner of the criminal petition, and several other reliefs as in the prayer, Lordship. At this moment, Lordship, I humbly pray for vacating the stay so that further investigation may be taken up and the
What Mr. R.
accused may
Sonal
be
counsel,
directed to furnish the original.
heard Mr. R. Sonal learned counsel appearing for the petitioner in criminal petition number 558 of 2024.
My lord, I have some more.
We are not passing any detailed order right now. Who also appears for the respondent number 2 in IA number 1308 of 2025. Mr. M.K. Agarwal appears for the respondent number 2 in the criminal petition 558 and for the petitioner in IA criminal number 1308 of 2025. The criminal petition had been filed seeking the quashing of the police report case number 87 of 2023, 878 of 2023, corresponding to Lotasil Police Station case number 326 of 2019, quashing and setting aside of the FIR dated 10/10/2019 filed by the private respondent, and for quashing and setting aside of the impugned order dated 2/6/2023 passed by the Learned JMFC, taking cognizance of the offence and summoning the petitioner in PRC case number 878 of 2023. Full stop. After arguing for some time, the learned counsel for the respondent number 2 in the criminal petition has submitted that has prayed for calling for a report regarding the availability of the original agreement, which is the bone of contention, which was purportedly executed between the petitioner in the criminal petition and the respondent number 2. Full stop. The learned counsel has submitted that though in different litigation, certified true copies have been annexed, there is no statement as to where the original agreement is available. Full stop. The learned counsel for the petitioner in the criminal petition has submitted that due to the objections given and due to the bar available at section 195 of the CRPC, the learned trial court could not have taken cognizance of the complaint. It is the stand of the counsel for the respondent, it is the, no. We have said Mr. Agarwala appears for the respondent number 2. You will change all that. You will say Mr. Agarwala appears in person as the respondent number 2. So what to change? While it is the submission of the respondent number 2 that the bar would not apply since the document is not in the records of the court, and therefore as per the judgment of the Supreme Court in Iqbal Singh Marwa versus Minakshi Marwa, reported in 2005 4 SCC 370, comma, a private complaint or an FIR would be maintainable. So what are the other documents? What more are given here? Achha, these are the three, na? Stop. On the next date fixed, the petitioner shall place on record the particulars as to where the original equipment rental agreement executed on 20th day of January is available. Stop. The petitioner shall also clarify the objection. No, also shall the petition shall also clarify the submission of the respondent that the petitioner had been summoned and interrogated by the police in connection with Dibrugarh PS case number 442 of 2018. Just a minute. Mr. Agarwal, you had referred to that final charge sheet, is it not? To show that the petitioner was not arrested on compliance of notice of 41A CRPC.
Lordship.
And you had referred to page 80.
Lordship.
This is not the Dibrugarh police case, is it?
No, Lordship. We are with the
Now,
Lata case.
just a minute. Just raising your voice is not helping anybody. Rein your horses, sir.
Lordship.
Come to page 13.
Page 30.
1.3. You had pointed out paragraph 5.15 to show that now this statement regarding never summoned is regarding the Dibrugarh PS case number or the FIR lodged here, the charge sheet.
May I, Lordship?
Yes.
It's Lata Seal case 326 of 19, Lordship.
Where do we have that?
Lordship,
Okay.
this is a criminal petition with respect to 326 of 19.
Yes, with regard to the objection raised by the petition by the respondent that the petitioner, while stating at paragraph 5.15 that he was never summoned or interrogated, the charge sheet clearly reflects that he was not arrested due in compliance of the notice under section 41A of the CRPC. The petitioner shall also clarify on the objection raised by the respondent that the petitioner had not received any summon in connection with the PRC number 878 of 2023 and yet an uncertified copy of the charge sheet without the FSL report has been annexed to the criminal petition. Stop. List this matter again on when can you get the information, sir?
This 27 March.
27th of March. This is the matter again on 27th of March. Now, why we have sought for this is, if these clarifications are not on record, these arguments will go on for all time to come. The matter will just be in the air. Once we have the clarification by whatever process, we can take a decision on it. So, as of now, Mr. Agarwal,
Lordship,
these are questions which you have raised, and these are answers which we would require.
Lordship,
Therefore, we are fixing it up on the 27th.
Lordship.
Once these questions are answered, we can go ahead to take a decision, because it is only at that point of time your preliminary objection regarding the maintainability can be decided.
Lordship.
If it goes on the maintainability, nothing remains to be done. If we find the answers to be effective answers,
Lordship.
the maintainability will not be an issue. We will
Lordship.
go to section 195, what he has argued,
Lordship.
and the judgment that you are trying to say does not debar the cognizance.
Lordship,
So we'll have it on the 27th.
Lordship, I have a humble prayer. We have the trial court on 27th. So can it be a day before on 26th?
26, I have some engagement.
Or 25th, Lordship?
We'll have it on the 27th. Whatever is the process in the trial court, you inform the trial court that the matter is today fixed before the High Court, and then you can fix another date.
My lord, now.
Lordship, if that is so, I humbly bow down to my lords. My lords can kindly take an indulgence to kindly come to page 81A, Lordship, which solves everything, Lordship.
We have closed the file. We'll
Oh,
have to
okay.
take care of other matters also.
Now, my lord, when a trial court is not taking up the matter, since the matter is pending before, that's why, my lord, nothing has been issued. So, this Mr. Agarwal, he has been approaching again and again, but no someone has been issued.
On 27th, you have the court.
So, I think nothing will.
You would also take the pain to inform the court that the matter is listed, and they can have it after a week, because 27th, I think we are going to go this way or that way. Okay, on 27th.
Lordship.
All right.
Then 6.
6 to keep.
May I plead your lordship?
Yes.
Lordship, in this case, trial court report was called for.
As if we have gone through.
Yes, Lordship. That dumper accident case, Lordship.
Yes, sir.
My lord, yes, we've gone from almost 1 hour. My lord, we have not, regarding service complete. Response number 2 is there. Because of that, my lord, we have not gone through. 2 is also there, my lord, regarding service of personal.
Then we'll take it up on some other day.
I'll go through, my lord, I'll go through.
Go through it. We'll take it up on 18th. 18th of March.
Well,
List again on the 18th of March, allowing the learned APP to go through the TCR.
Obliged.
Then 7.
Yes. Deciding outside the court. Decided?
No, my lord.
Not decided.
No decision. I am praying, my lord, 2 weeks time, my lord, for final hearing. Fix them around for final hearing.
Okay. Sir, we'll fix it for hearing. Suggest a convenient date.
Actually, the case that they have referred, Madanlal case, is not applicable here.
No, we understand all, but we have to rise at 3:15. So we'll not be able to dictate the entire order.
My lord, as far as possible.
Your choice, sir. He's praying for a date, that choice is yours.
Sorry.
Tell us. 19th? 19th of March?
Can it be after Eid, my lord?
Okay. 26th? 26th? 26th March?
26th March.
Huh?
Okay, man.
26th of March for hearing. Mr. So-and-so appears for Mr. I. Sekia, learned APP. Mr. R.C. Sekia, learned Senior Counsel, assisted by so-and-so for the respondent. 26th?
Oh, last time.
The report, has it come?
Well, earlier IO, my lord, he got transfer, my lord.
Ah.
New IO has come, my lord.
Ah.
So, my lord, we have not received the report, my lord. Actually. So, my lord, we pray for some time, my lord.
Next week, my lord. Oh, Kamrup, my lord.
We'll have it on 19th?
19, my lord.
19th of March?
Yes.
19th of March.
Can it be 18?
18th of March. 18th of March, awaiting the report called for. নিশ্চিত সিং পেটেন 92 যোৱাবাৰ মোক কোৱা যে মনত পৰে the same problem bugs me. I have to rise early. And if I go through all the orders.
Well, I was under the impression that the matter would come for delivery of orders, perhaps.
No, we did not keep it as a. We did not want to pass the order inside the chamber and then have it delivered.
That could also
What I had in mind was that while dictating the order, I could have the assistance of both the councils on different
Definitely.
aspects. Therefore, I had kept it fixed today for delivery of the order.
Perhaps next week sometime, subject to your lordship's command. 17th, 18th, 19th. and-
17? On 17th, we'll take it up for discussion. 17th for delivery of orders, huh? Due to paucity of time. List again on the 17th for delivery of orders.
Perhaps it could be fixed at 2 p.m. It might become easier for your.
We'll take it up.
Early.
Today we are a little bit hard pressed, otherwise we would have done it.
Team develop.
Yes.
In this case, my lord, as per last order, lordship, they have filed an affidavit today.
Today we
We
have.
have received, lordship, which is not in the record, so some other day. But at 3/2/2026, thereafter another date is there. Today they have filed it.
The affidavit, no, it has been submitted that the affidavit,
Additional affidavit.
additional affidavit required to be filed on behalf of the Department of School Education has been filed today morning. We'll stop the learner counsel for the petitioner's place for some time to go through the same. Matter was heard at length on 3/2/2026. And was kept as a part-heard matter. List the matter again on. When do you want it?
7 days.
Hmm?
7 to 10 days.
On 12th of March. On 12th of March, either you argue the whole of it or we release it.
Was
12th of March, either you argue both the sides
on
or
12.
we release it. Yes,
Lordship may kindly peruse the last.
yes, APP. We require some assistance. This driving license, PAN card, voter ID, ATM cards, COVID vaccine card, Aadhaar card, why does the IO need them?
Yes, my lord.
Huh?
That report, my lord, we have received, my lord.
Ah,
Not.
Release this.
Huh?
Pay.
No, this is the report, my lord. Lord, to make kindly service. Very good.
No.
you are allowing the person to go on bail. This person is on bail, is it not?
Regarding, my lord, voter ID, Aadhaar card, my lord, that expert report, my lord.
What?
That regarding the voter ID, my lord.
Ah,
So that as per the report, my lord,
ah.
is not seized, my lord, probably, my lord. Because the FSL report, my lord, of the mobile phone has not received, my lord.
Yes, madam. PAN card, voter ID, driving license, ATM have not been
Yes.
seized.
Lordship, it's taken by the police. The
No, it is
investigating
all right.
officer has taken
Now,
it.
these are cards which you can always get a duplicate on proper application. This report is there, we'll record it in our order that these have not been seized by the police. So therefore, now you you lodge a GD entry that these are not available with me. I need a second copy of this, therefore this GD entry. Apply and you get the other copies. These copies can be always obtained otherwise also.
From the police?
Not from the police. The police, when they are saying we don't have it, now we cannot ask the police to go and look into the police drawer to find out if it is there. Once they deny taking that, what can be done? Expert opinion on what?
No, regarding the mobile phone, my lord, that FSL report has not.
No, what do you want to know from the forensic person regarding the mobile?
Regarding my lord, about the my lord, the allegations made.
What allegation? The allegation is that they had demanded money from some persons. They were helping other persons pick up ransom. Is it not? So what will the forensic find out in that?
Until unless the mobile phone is, my lord, released by the FSL report, FSL, my lord, we cannot hand it over, my lord.
So look, forensic report, you have to ask for certain things from the expert.
My lord.
Whether this phone was used in this kind of thing, whether it contains this kind of record. You must be asking something from the FSL.
My lord.
What have you asked for? Simply because I possess a phone and I am arrested. What FSL report from the phone?
No, my lord, that prayer is to, my lord, give Zimma of the, my lord, mobile phone, my lord.
Yes.
Now the mobile is, my lord, in the FSL, my lord.
I understand it is in the FSL. Now, if you're sending something which is from which some information will be taken out, you will have to tell the FSL expert that this is the information. Can you tell us?
That we have already apprised, my lord.
What?
But
Where?
we have-
That is what we are trying to find out. What kind of information is taking so long?
Lordship, may kindly produce
Huh?
para number 9 of page number 14 of my petition, Lordship. Para number 9. Page number 14. It's the bail order from the ordinary bench of this honorable court. Para number 9, it says that, may I read, Lordship?
The learned APP has produced a report from the Crime Branch Police Station, public investigating officer of the case, that no other items such as PAN card, voter ID card, driving license, ATM card, or COVID-19 vaccine card or Aadhaar card in the name of the petitioner hearing were seized in connection with the above mentioned case. Full stop. In such circumstances, the petitioners would now be at liberty to apply for fresh copies of the aforesaid documents, since the IO has submitted that the documents were not seized and therefore impliedly they are not required for the investigation of the case. We'll give you the liberty to apply for fresh. Okay?
Also the phone, mobile.
Huh?
Mobile phone, Lordship.
Mobile phone, we are coming to that. The allegation as the allegation against the petitioner as reflected in the order dated 18/9/2025, passed in BA 2858 of 2025, is that the present petitioner had brought the co-accused to work at a particular place, and later on the co-accused were found to having links with a proscribed organization. Full stop. On the next date fixed, the IO of the case shall produce a report before this court as to on what aspect the FSL, the mobile phones seized have been sent for FSL opinion, for expert opinion of the FSL. Full stop. The report may be given to the court in a sealed cover.
A copy of the order may be furnished to you.
A copy of this order will be furnished to the learned APP, who shall forward the same to the IO and also to the Director of Forensic Laboratory, requesting him to inform the court as to why the preparation of a expert opinion on a mobile phone is consuming so much time.
Let the matter may I pray, Madam, let the matter may come up in the last week of March.
27th March?
27th March.
List the matter again on 27th March. Look, it has.
Lordship, I have little inconvenience as to 27. Can it be later or can it be little
31st?
prior to 25 or
31st? 31st will do? 31st of March.
Yeah,
Huh?
31st March.
One
obliged?
delivery of order.
Yeah, paucity of time does not permit the orders to be delivered today since the court is rising early. List the matter again on 11th of March.
Timing item 23.
This case, my lord, investigation completed, search is submitted. My
When?
lord. On 23/1, my lord.
23/1.
Prior to filing.
Huh?
Prior to filing?
Yes.
Prior to?
Prior to this filing is February.
Huh?
Let this year may be called for lordship.
The learned APP has submitted that the matter has culminated in charge sheet number.
Charge sheet number 2/2026, dated 23/1/2026.
Call for the scanned copy of the trial court records. List again on 20th of March.
TCR lordship regarding TCR, it will come or not?
22.
One more time, huh?
20, my lord.
I said 20. He's
Come,
expressing
my lord, scan copy, they will send through
Huh?
mail.
through mail. It comes through mail. Scan copy of the TCR. Come through mail on 20th of March.
Highly obliged.
Item 15.
Yes, my lord, we have inquired, my lord, here, my lord, CD in session judge in connection with, my lord, one Rohidul Islam accused.
Not these persons.
Not this person.
If then we are allowing them to go and appear. Yes, we'll allow them to go and appear. Have you seen the trial court order? Yes, please go through it. Give it to him. Same case, named accused. Okay, come to page 2. You are named here. One of you is named, and one is unnamed. 2 and 3. Named accused have been allowed to go on bail. So we'll only allow them a pre-arrest bail. We'll allow them a interim bail. Let them go and appear. We'll have the CD. If we find that they were the involved persons, we'll recall it. And if we find that they fit into this, happy go lucky. Huh? Heard Mr. M. Mondal, learned counsel appearing for the petitioner. Also heard Mr. K.K. Parasol, learned APP. Steps on the respondent number 2 were taken on 19/2/2026. However, no service report has been however, no service report is available. On the last date of listing, that is on 2/3/2026, this court had noticed that the trial court has granted bail to the accused who were taken into custody. And since the statement of the alleged victims did not implicate the accused, and the learned trial court has also taken into consideration that no TIP was done to identify the accused persons by the victim. The length of judicial custody had also been taken into consideration by the learned trial court. In view of the findings of the learned trial court, this court deems it, the court, this court is of the opinion that the investigation in the matter will be favored if the petitioners herein are allowed to appear before the investigating officer to participate and cooperate in the inquiry. Accordingly, the petitioners shall appear. The petitioners, namely so and so, shall appear before the investigating officer of Lakhipur PS case number 168 of 2025 on or before the 12th of March 2026 to participate and cooperate in the inquiry. In the event of their arrest, they shall be released on bail on furnishing a bond of rupees 15,000 each, with 2 sureties of the like amount, subject to the satisfaction of the inquiring authority. The learned APP shall have a report on the service of notice on the respondent number 2 on the next date fixed. Full stop. It is made clear that the protection granted to the petitioners herein is only to facilitate the investigation, and since other co-accused have been granted regular bail by the trial court. Full stop. The petitioners will not interact with the victim, the informant, or any other witness who may be vital to the investigation of the case. Full stop. Further continuance of the privilege granted today shall be considered upon receipt of the case diary and the report on the service on the respondent number 2. So please again on 25th of March 2026. Go and participate.
Yes. Obliged.